Yes, Lordship. One unlisted matter, Your Lordship. It was listed earlier on 2nd. Lordship were not there. It was went to the
What's
other
the matter
court.
about?
It's a matter about, Your Lordship. We are petitioner is a small contractors associations, and they cannot execute the work of a very high amount. Now, the department, what they have done is that they have consolidated the ancillary work with the main work, resulting thereby.
Where's this project?
A project is in Upper Shillong. That veterinary department, let it come tomorrow, Lordship.
May I please, Your Lordship? I beg to mention item number 37.
Mohammed Zahir.
Mohammed
Why?
Zahir. Your Lordship,
You withdraw it then. You're not interested anymore.
2 weeks time may be given. Your Lordship.
You'll withdraw.
No, Lord, I'll take instruction, Your Lordship.
As we'll have it tomorrow. Finish it off. What remains here?
Nothing, Your Lordship. The school managing committee is
I have to take
Carrying on
instruction.
with
What
Your
instructions?
Lordship. Whether we have to withdraw.
Tell the court what instructions they have to take.
Yes, sir.
Yes, which is the what instructions they have to take.
My lord, instructions were
The
to
appeal is not interested anymore. Your
my lord, the petitioner appears to have lost interest. Give us a week's time, my lord. Just give us a
Okay,
week's
1
time.
week. Otherwise, just adjourning proceeding, adjourning will
Well,
not solve anything.
Understand.
Yes.
And 38 is also a connected matter, Your Lordship. Same managing committee. Whether you're going to take it up?
1 week, okay.
May you please, Your Lordship, I beg to make a mention on item number 35, Your Lordship. I pray that this matter may come up to 2 weeks, Your Lordship.
Why?
No objection.
1 day, why so many adjournments? Yes.
No objection.
What's the problem?
Your Lordship, the conducting counsel is having health
Not
problem
well,
with his
Mr.
health
Sen.
issues.
He's well or he's unwell?
He's unwell, Your
He's
Lordship.
unwell.
Yes, Lordship.
Okay, yes.
Yes, Lordship. May it please, Your Lordship. Your Lordship, I beg to make a mention of item number 42, Your Lordship. Lordship, in this matter, I'm praying for 2 weeks' time, Your Lordship.
42.
Yes, Your Lordship.
So blood testing, what?
Blacklisting. Okay. No interim orders.
No.
No, Your Lordship.
He remained blacklisted. Okay, yes. 2 weeks. Yes.
Obliged, Lordship. May it please Your Lordship, I beg to mention item number 41. Your Lordship, the conducting counsel is suffering from mania disease and his
Lordship,
And
I have
41 who's suffering from?
mania disease and his condition is quite serious, Your Lordship.
This is the genitals, Lordship, fright matter,
Who are you mentioning on whose behalf?
Sir, I've been case in Sutunga. Respondent number 8 to 13.
Lordship, this is that fixed matter, Lordship. In fact, Mr. Hasan Mukherjee has travelled all the way from Kolkata, Lordship. Let it be taken up, Lordship.
We'll call it out.
Lordship.
Much obliged. May I please, Your Lordship, I'd like to mention item number 32.
Yes.
I'm here on behalf of Mr. B. Pathak.
Vacation still continuing, got you or over?
Your Lordship, he's suffering from some personal difficulties, so
Yes.
This matter was out there, supposed to bring some authorities.
2 weeks. Yes.
item number 1.
Supplementary list. On that one. Yes. Where's the?
Please, my lords. Madam, am I audible to your lordships?
Yes, yes.
Madam, sorry I could not appear physically today, my lords, due to the ongoing waterlogging, my lords. I'm stuck, my lords, in Guwahati. My lords, I just wanted
Are
to
you based in Guwahati or are you based in Delhi?
Mads, I came to Shillong, Mads, but I got stuck in Guwahati, Mads, due to the highway jam, Mads. I'm stationed in Guwahati right now and Mads, appearing, Mads. So, Mads,
There's a water log in Yoruba.
yes, Mads.
Even the airport authority people, they came from Rani.
from madam.
Yes.
Very well. Now let's may kindly have the impugned charge sheet, which is at page number 65, annexure P1 notes.
Yes.
My lords would see page 65 at the bottom. Your lordships would see it is signed by Under Secretary to the Government of India, Sunil Kumar Gupta. Your lordships, in my case, being the Group A officer, the disciplinary authority is the President. My lords, being fair to the Honorable Court, I would say that the first line of this memorandum does say the President proposes. Your lordships has para 1, first line. But my lords, as per the rules, and I will also show from their own record, that this charge sheet could have not been issued until and unless it is authorized and approved by the President. Proposal is not, my lords, sufficient to issue the charge sheet. Now, my lords, I would also show another document, but before that, I will complete what is the charges against me. Your lordships would come to page 67 now, my lords. I am reading from para 5, page 67, para 5 at the bottom. Towards the charges against me, the statement of imputation says it was evident from self-admission of so-and-so vide his letter dated 29th June 2022. Your lordships may for a minute kindly mark this. This letter of 29th June 22 is portrayed as an admission on my part, and I have placed it on record. My lords would see page 68, second line. It says willfully delayed the submission of inquiry report. Has your lordships got that?
Yes.
Second line of page 68. Thereafter, it's the third last line. Disciplinary authority by his letters dated.
There's a photocopy. Some words are missing, but we chief engineer. Yes.
Merz has much that I'll read the whole paragraph. Disciplinary
No,
authority
that is
despite
what
several reminders.
is missing. Is missing while photocopying. I think something came on top. Yes.
Merz disciplinary authority despite several reminders issued to the chief engineer Beacon and willfully delayed the submission of inquiry report to disciplinary authority, thereby violating the provisions of DOPT notification published in the Gazette of India vide so and so. He finally submitted the inquiry reports to disciplinary authority vide his letters dated 18 June 24 and 20th June 24 after a lapse of almost 2 years from his self-admission and time extension granted to him for submission of inquiry report, thereby causing inordinate delay of almost 2 years. What three things emerged from this? One is willful delay, a delay in the submission. Second is after a lapse of 2 years, and third is violation of DOPT notification. So now it's the first question which would arise is, what is that notification which has got violated?
Yes.
Merely saying you are an offender without telling in the charge sheet what law I have violated. That's the first thing I am raising. Thereafter, your lordships would have para 6. Second last line. As I'm reading from the middle of the second last line, which was in violation of statutory provisions and CVC guidelines. Notice again there is a mention that I have violated something. What I have violated, that doesn't mention. So notice it is like you are charge sheeting someone for an offence without even telling what section, what law under which I am going to be prosecuted. Notice may kindly have para 7. Shri Rakesh Chopra so-and-so being a government employee has apparently and deliberately caused delay in disposal of the disciplinary proceedings assigned to him, which was not only resulted in inordinate and unjustified delay. So much what the allegation against me is, I have caused unjustified and inordinate delay. And what finally comes the last and the most glaring paragraph, para 8. By above act, so-and-so has failed to maintain devotion to duty and acted in a manner which is unbecoming of a government servant in the performance of his official duties. But I'll pause here for a minute. What's the picture which is being given is that the petitioner herein being a government servant has not followed the orders, has not performed the duties which are assigned to him.
What is this? What is this first one? 1 second. Now the one in para 5. Which is that GSR 548E dated to June 17? Where is that? Then what are these next ones regarding this?
This is
sub rule
exactly
1
at page
or
70.
rule 3A? Yes, you just go there, yes.
But this is exactly at page 76. This is exactly at page 76.
Let's see that.
Yes,
Yes,
Lord.
that is-
Lords,
GSR
2nd June
548,
2017.
yes. What does it say?
Lords,
Which
my
part
Lords has
it is?
Roman
No,
3.
if they've quoted it, that means that they say that he this is violating provisions of this notification. Which part of the notice has been violated? Let
Page
us see.
76.
Yes.
Page 76, my Lords,
Yes.
has Roman 3, which says
Yes.
after sub-rule 23, the following rule shall be inserted. Namely,
Yes.
has your Lordships got that?
Yes.
Page 76, 2nd June 2017.
6 months.
But I'm reading clause B.
What about
Where
8?
it is not possible to adhere to the time limit specified in clause A, the inquiring authority may record the reasons and seek extension of time from the disciplinary authority in writing, who may allow an additional time not exceeding 6 months for completion of the inquiry at a time. Your Lordships may kindly mark this word at a time.
Okay. Yes. That's
So,
true.
my Lords, now allow me, my Lords, to come back to the my Lords, charge sheet which I am, my Lords, challenging. Page 68.
Yes.
The picture which is presented before issuing this charge sheet is that I am a government servant. Roles are assigned to me and I am doing that.
Yes.
The first thing which this memorandum of charge sheet fails to take into consideration is acting as an inquiry officer is an act which I am doing beyond my official duty.
Yes.
I am being appointed as a quasi-judicial authority to act as an IO. I was not appointed in this government job to act as an IO. IO performance as an inquiry officer is on the basis of my capability, on the basis of my integrity, on the basis that the department feels that yes, I am fit enough for that. First thing, my lords. Second, my lords, when they say statutory provisions and guidelines, they have to show that non-completion of this inquiry within a time frame is a misconduct.
Yes.
Particularly when this is an act which is beyond my duty. And my lords would be aware, my lords, acting as an IO entitles me to an honorarium because I am doing something which is beyond my act which I am doing, my lords. But my lords, that would have been my case had there been a delay from my side. So my lords would for a minute recollect that there is a self-admission letter of 29th June 2022. Your lordships, I have already read that. My lords, may kindly have page 79. I'm sorry, Muds is already aware of a few things in this matter, so I will quickly go through so that I do not waste the time of the Honorable Court. Page 79, your lordships would find the first court of inquiry which was issued against me in July 2022. So, my lords, within 1 month, July 2022, there is a court of inquiry initiated against me and the allegation against me is of doubtful integrity. Your lordships would recollect that there was a court of inquiry. So the fact is the department which is now coming to me saying that I have delayed the submission of inquiry report is the same department who, while they appointed me as a quasi-judicial officer, as an inquiry officer, they alleged my integrity is doubtful. My lords is with me, my lords?
Yes, yes, continue.
So my appointing authority as a IO is the same department which challenged my integrity and which said that it is doubtful.
Yes.
So, nerds, what I did was, and nerds, this is a series. Page 79 is the July 2022 Court of Inquiry. Nerds, page 81 is the September 2022 Court of Inquiry. Again on the same, integrity is doubtful.
Yes.
Page 86 is a CVC order. Page 86.
Yes.
Being a whistleblower, CVC had to step in and say that COI ordered wide so-and-so of 23rd September may be kept in abeyance till further orders. So CVC protected me. They directed the respondents, keep everything in abeyance because he's a whistleblower. But what the respondents thereafter do is, there is a petition pending in a Delhi High Court. In that, the respondents allege that I am a person of doubtful integrity in January 2023. So, my lords, I have showed July 2022 court of inquiry, September 2022 court of inquiry, and my lords, January 2023 on a affidavit in High Court. My lords, may kindly have page 250 of the petition.
Yes.
Para 101. Has your lordship
Yes.
got that?
Yes.
The petitioner has become in a pathetic mental condition and he has been misconceived with partial facts and frequently making claims at his whims. What's the next page? Para 105
Yes.
has the last part. The case of petitioner is not recommendable due to clause D, due to doubtful integrity of the petitioner. Has your lordship got that?
Yes. Yes.
Page 252, my lords.
Yes.
I'm reading from the fifth last line. The integrity of the petitioner may be inquired upon. So, my lords, the respondents during the appointment of myself as an inquiry officer at multiple places say that I am a person of doubtful integrity. I have committed an act unbecoming of a uniformed force. Once, as a dutiful officer, what I do is, my lords, I send them a letter. Your lordships would kindly have page 152 now. In fact, my lords, probably after this, I should not even argue what I am going to show now. But, my lords, I will show that your lordships, they have violated even my lord's judgment of 24th November. Your lordships has page 152. This
Yes.
is a letter of 24th May 23.
Yes.
Once may kindly have para 2. In a recently filed counter affidavit in Honorable High Court of Delhi, in which you are one of the respondent, department has cast aspersions on my integrity and intimated that I did act an unbecoming of a disciplined officer, and court of inquiry was convened long time ago in the month of July 22 to investigate these. Knowing well the department stand, you keep on writing me reminders to complete departmental inquiries without giving a thought whether an officer whose integrity is alleged under doubt by department can continue the DEs or not. It is also stated in the counter affidavit filed by department that my mental stability is doubtful. It may be informed whether I can continue the DEs in my alleged present condition. I am asking the department and the disciplinary authority, please tell me in the backdrop of this, can I continue as an IU or not, my lords? But, my lords, may kindly have page 153. And I would, my lords, take a minute and read the whole of it because, my lords, this should lay the matter to rest. 27th March 2024. Has your lordships got that?
Yes.
Page 153. I'm reading from the first paragraph. It is noticed that references given in your department letter so-and-so, aforementioned at so-and-so, start from date 15th
Now they
January
reply to
22,
your, listen 1 second. They reply to 24th May 23 letter in 27th March 24.
They never replied to it. Till date, there is no reply, my lords. That is what I want to show. But, my lords, 27th March is another reminder, and I have sent 4 to 5 reminders.
This is your letter.
I have placed
also.
on record too.
Okay, yes, yes.
These are my letters asking clarification. Please tell me, can I continue as a IU or not?
Yes,
But,
okay.
my lords, 27th March is, my lords, I would want to read. My lords, I'll trouble your lordships for
Yes.
this. Notes I'm reading from the second line. As due to COVID problem, normal period for completion was increased from 6 to 13 months by the DOPT CBC. CBI report to charged officer was provided by disciplinary authority on 7th November 21. So 13 months are to be counted from November 21. So normal completion time should be December 2022. Department was never interested in completion of DEs as it is obvious from I have been posted out of headquarter Beacon, the place of incident and location of DEs before completion of my normal tenure of 2 years. As CVC circular, IO should not be transferred during the proceeding of DE unless there exist exceptional circumstances. The main concern of department was to penalize me for being a whistleblower, reference number so-and-so, to inflict humiliation. My office was locked without allowing me to take out my belongings. Military police was used to get government office vacated from me. I was put under extreme pressure to vacate my accommodation and administrative support was taken away from me. Back to back, 2 court of inquiries were started against me for the reason no court of inquiry ever held in the department. Let me kindly mark this. I was in court of inquiry initiated against me. In the history of BRO, never has that been alleged as a misconduct. In first court of inquiry, I stood discharged and another court of inquiry was stopped by CBC. I just read that for my lords. It has been found that there is a deep lack of knowledge and appreciation of departmental inquiries and role and functions of inquiring authority in the department. So it is pertinent to mention that serving officer when appointed as inquiring authority ceases to be a government servant for the purposes of DE and he discharges quasi-judicial functions. This is not his normal part of duty. IA gets honorarium as remuneration for this additional work. Sanctity of the appointment is so high that even if accused blame the officer of being biased, then that officer cannot hold the appointment of IA. In my case, department has put so many baseless allegations me in their counter affidavit, especially doubtful integrity, indignity, mental health, crook, etc. filed in the Honorable High Court of Delhi in writ petition so and so. I would have, your lordships may kindly mark this, I would have relinquished from the appointment of inquiring authority if there had been any provision or precedent of resigning the day inquiry was convened against me to maintain the dignity of the appointment. Hence, I stopped performing the functions of IA in the wake of inquiry against me. Apropos, the undersigned wrote a letter to the disciplinary authorities of JEs, CEs, Beacon to confirm whether in view of present allegations made by the department, the undersigned could still continue to be inquiry authority in the 3 DEs. Neither CE Beacon nor headquarter replied to this letter. Their silence on this important query was bewildering while they keep on sending infructuous routine reminders without addressing core issue of the officer who is under allegations of doubtful integrity and mental instability can continue with quasi-judicial functions.
Okay.
As if this was less, just one more paragraph.
Yes.
As if this was less, DGBR served show cause notice wide letter number 27 June 23 to the undersigned for function being done as IA questioning my integrity. Though while discharging the quasi-judicial function as inquiring authority, the undersigned did not come under DGBR. The issue of SCN was in complete contravention of laid down guidelines. But last line. Apropos, it is again requested to reply to my query raised by my letter referenced in para 1, which is the May 2023 letter. Now, my lords, this is March 2024. What happens, my lords? Your lordships may kindly have page 176 now.
My lord, may. This is a motion stage, my lord.
Now let's see,
We are yet to file
we are
affidavit,
seeking
my lord.
interim relief.
If they are seeking,
I am seeking interim relief, my lordships. Kindly give me 2 minutes.
Are you seeking interim relief or not now?
Just 2 minutes.
No, Mr. Gupta.
that
Just
comes
2
memorandum
minutes
of charge, my
more.
lord.
Merge just 2 minutes more.
Memorandum of charge of 19th
Just
May, my
2
lord,
minutes.
is about a month. I'll file affidavit within a week to 10 days time, my lord. The
No,
matter is clear.
just 2 minutes more, my lord. Allow me to show 2 things. This writ petition can be
No, you can
decided
show it
today
to final hearing. They
itself.
can
Just
show
2 minutes.
We
everything.
can decide today itself.
Can't be, but we
Yes,
have to
my lord,
file
I
affidavit.
will show it.
I have to
I
file
will show
affidavit.
it, my lord.
So give me 10 days time, my lord, we'll file
Thing
affidavit.
is that, Dr. Mozika,
But
this
just give me
thing
2
has
minutes,
gone on
my
for
lord.
too long. I mean, it's become like, this called a never-ending story. Now this is the third
What?
repetition.
Just give me 2
My lord,
minutes.
most probably, most
I
probably
will
this is
show it from
In
record.
this court, Mr.
most
Gupta,
probably
please calm down.
most probably it is fifth in this court, my
In
lord.
this-
Delhi High Court there are some petitions, my lord.
It's the fifth repetition. It's the
Not the
third.
fifth, my lord. There is a pending division bench matter also, my lord. There was an appeal that has been disposed of.
Now, Mr. Gupta, this is the third or fourth repetition in the before
No,
the.
I have forgot the count. But I have forgot the count, my lord. I'm so sorry.
So that
But I have actually forgot the count. My lord,
He is on
in
the
fact,
verge of
my lord,
it.
the respondents will apprise if there is any case in which I have lost. Any case in which the
No, we're not
honorable
saying
court
winning
has
or
said
losing,
that this
but
action-
it becomes like, the thing is that
But
it's just
every
as
case
if
their action is held to be
it's a
arbitrary.
war of attrition. Because this court
No, it's like-
in 25 set aside the charge sheet, right, giving you liberty
My
to
lord.
go in accordance with law, right?
My lord.
Now, what you have done after that, then
This is
it's
the-
just
this
again,
is the-
digging up the old issues with regard to
But
non-completion.
in 20
Now, whether the charge non-completion will amount to such, that an attrition from the part of the department, you surprise the other more serious matters which, the department sleeping. But in the case against one officer, how how all, the entire
9
machinery is being
days after
activated.
10th June order.
Malo, that is
9 days after
And
10th
after-
June order, they issue charge sheet.
Yes, issue another charge sheet.
Malo, lots of staying.
9 days after
I
the
don't
lordship's
mind,
order.
Malo. Kindly give me 10 days time, Malo. We'll
Yes.
file affidavit. My submission will be that it is issued on 19th of May, Malo. Today we are on 13th of June.
Whatever it is.
It is 25 days.
It is 19th of
Where,
June.
Mr. Gupta, in the earlier writ petition, where the interim order was passed? The last interim order?
Malad, in the earlier writ petition, it was not passed because I had time. Now the promotion is due. DPC is sitting. Your
No,
lordship,
regarding
24th
opening of seal
November.
cover. When, which order is that?
We have opened the seal cover, Malo.
No, it's been opened now. When,
Respondent has to price.
no, when, which order was that? When this court directed that a seal cover be opened?
But it's 10th of June 2020.
That's why I'm hearing him for so long, just to get, an idea as to what has happened and why it's taken such
No,
a
it
turn.
cannot be that our entire BRO is after one person, Malo. He is the superintendent.
It looks like that.
But Malo, kindly
Why
see,
after one
Malo,
person?
kindly see the conduct of the petitioner. He is not allowing the department to function, Malo.
No, if a person has come to court, I mean, this is.
Because the department only wants to function against me. It doesn't want to perform its duties.
No.
Yes.
I can't say anything. Malo. The BRO is a large organization. And he is not happy with BRO, but he is free to go somewhere else.
That's why even for interview NHIDCL also he said it's misconduct, integrity, why did he go to NOC? I saw from the record.
CVC
Just now.
first aid
He can
advisor-
resign and go, Malo. Whose topic? He can resign and go.
When I was going on deputation.
No, you're not for you to argue, Mr. Chopra. Otherwise, we will, your counsel not argue, then you can argue. You want to represent person.
And that also jurisdiction doesn't lie before this honorable court, Malo. Earlier matter. In the writ petition, something different. The file in this case is something different, Malo. Lots of grave intelligence, past order, in spite of that, Malo. Where you raised a preliminary issue of jurisdiction in that matter, Malo. And admitted position, one writ petition is pending in High Court, Malo. For department also, it's much easier to defend in
Matter
High
Delhi
Court,
still
Malo.
pending.
It's still pending, that's what they said, Malo.
Which matter? No.
That's what is submitted just now.
Mr.
The matter is
Gupta,
pending.
regarding the affidavit was filed, seeing about his mental stability and his integrity, is that writ petition still pending in Delhi High Court?
I was about to argue. 8th of May 2024, High Court categorically said the petitioner is of unimpeachable integrity.
No, has it been disposed or still
Arbitrary
pending?
and unjustified.
Mr. Gupta,
It is disposed of on 8th of May. 8th of May 2024. That is what I was showing on page 176. Disposed of on 8th of May
Okay, yes.
24, June 2024.
Give me 10 days time.
Submit the reports.
Give me 10 days time, Malo. We will file affidavit, Malo.
yes, heard Mr. N.K. Gupta, learned counsel for the petitioner.
Merge, may kindly consider granting
Yes.
me interim relief, Manoj. Merge, they have
Yeah,
no
one second,
first stage CVC
please,
advice.
yes. Issue notice, Dr. N. Mozika, Leonard DHI with MSc Jala is present and accept notice on behalf of, or not present and no further is required on all the respondents.
No, Malo. There are some individuals.
Or CVC,
Not only CVC, Malo, the retired army officers.
formally, Dr. N. Mozika is present with Jala on behalf of respondents number 1,
1, 2,
2,
4,
1, 2, 4,
5, Malo.
5
And 8 also.
and 8. So notice to issue to remain respondents within 3 days. Stop. The Mr. N.K. Gupta submits that you can't remember, this is the what round litigation. Anyway, this is another petition whereby the petitioner is assailing the impugned charge sheet dated 19 June 2026. Stop.
What's 19 June? It is the first case, but your lordships asked generally how many rounds of
No,
litigation.
there's no, you're challenging now 19 June 2026.
But this is the first case against 19
Yes.
June.
First case 19 June, of course, the new cause of action.
Again, yes, Manoj.
It is submitted that the instant charge sheet relates to incidents that occurred since June 2024 with regard to non-submission of inquiry reports when the petitioner was appointed as the inquiring authority. Stop.
In May 21.
Yes.
In May 21. I was appointed in May 21.
Yes, in May 2021. Stop. They submitted that the entire after, when was the first charge sheet issued to you?
Merge, the first charge sheet is of 22nd April 2025.
Yes, this submitted that the fresh charge sheet has been issued in spite of the earlier charge sheet dated
22/4/25.
Merge, 22nd April 2025,
being
page 206.
quashed and set aside by this court,
On 24th
and that
November.
the
24th November.
respondents acted in a pointed and a malified manner. Stop.
Without CBC first aid advice.
Different manner. Learned counsel also pointed to the defects which he submits appear from facie on the face of the record. Firstly, with regard to the whether the same was issued by competent authority, and whether what is your, and with regard to the articles of charge that have been framed therein, which change in article charge framed therein, which a respondent attribute to the action of the writ petitioner itself. The counsel submits that the entire the articles of charge also are misconceived and are misconceived. Misconceived in as much as performing as an inquiry authority is beyond official duties, and whether the same would amount to misconduct is debatable and stuff. Next paragraph. Dr. N. Musika, London, DSGI, with also prays that he be without how much
10 days time.
10 days time to file, to get instruction to file affidavit stuff. Prays allowed in consideration of these submission, the materials that are available before the court today. In the consideration of the court. In a considered view of this court, a prima facie case is made out for some interim protection at this stage. Accordingly, is provided until the next date. The memorandum of
Let the proceedings be stated, not the memorandum.
yes,
There are no further proceedings pursuant to
no further proceedings should be further from the state on the basis of the memorandum dated 19 June 2026. Yes.
19 June minutes.
This also.
Notes may kindly consider adding the word effect, because notes what will happen is the proceedings are stayed. However, notes they will use this to adopt the sealed cover for the next promotion for
If they are asking for question today, my lord, at least we are entitled to one opportunity.
Okay. Yes.
So may I say something, sir?
Notes, may I just
I was a inquiry officer.
Enough. Your case is over. We're not going to. Yes. Next
Please,
matter.
sir, let me say something.
Oh, please, we'll have next matter, please. We can't give you so much indulgence. Just because the court sympathetic doesn't
Sir,
mean that you.
Sir, two lines, sir, only 2 lines.
Please, Mr. Chopra. Otherwise, we will.
I'll start speaking, my lord.
Disengage.
Has he taken leave from his office? My lord, every day he is in court.
Disengage the lawyer.
Mr. Chopra,
Please, sir. Otherwise,
Mr. Chopra, please.
please will the counsel.
Mr. Chopra, let it be. Mr. Chopra, let it be.
I disengage the counsel.
I'm so sorry, Manoj. I'm so sorry, Manoj. I'm so sorry, Manoj.
Item number 2.
Just request one thing, Manoj. Manoj, item 40 is also listed today, Manoj. It is listed for final arguments. Manoj, I don't think, Manoj, I'll be able to assist your lordships online, Manoj, in a final
Together
argument
next date,
matter.
yes.
Manoj,
Okay,
consider posting these matters on 27th, Manoj, if it is convenient to your lordships.
Yes,
Manoj,
next
post these
day.
matters
Yes, next day.
27th, Manoj. I'm so obliged.
Item number 2.
This is regarding the property in Bangalore.
No, in Shillong, my lord.
But this.
My lord, if I may take 2 minutes, my lord.
Was not.
My lord.
Did I conduct the matter in this Bihar earlier on?
A long time back, my lord, in different matter, my lord. In different matter. This was not the matter, my lord.
Even then, this name is very familiar.
Yes, my lord.
Cuba, right?
Yes, my lord. Long time back, my lord. Maybe about 15-20 years back, my lord.
Even then,
My lord.
yes. Let us go to the bench.
Very well, my lord. Deeply
Please,
obliged.
bench drawer. I remember this person.
Yes, ma'am.
He got Indian citizenship. Chinese. Yes.
Very, very correct, my lord.
Item number 3.
Obliged, my lord.
mediation committee, you have received any instructions?
No, my lord.
No, you wait now. Your matter, you'll get instruction mediation committee. You sit down, we take up the matter.
Okay.
My lord, in the main matter, as apprised on the last occasion, my lord, the yatra is to take place on 9th of August, my lord. Last year,
Now let's come back to the last order regarding committee.
Committee, Your Lordship, we had submitted a list.
You know, when is that?
my lord, kindly looks at 10th July order, 10th July
10th July 2025, Your
2025.
Lordship.
2000?
25, last year.
10 July. (2025).
25.
1 second.
Initially, a committee had been constituted by the state respondent to which the petitioners raised objections. So we have given a list now of the entities and persons to constitute the committee. List is dated 14th May 2025.
Where's that list?
List, Lordship,
Did you
I've
give by
got a-
affidavit?
No, Your Lordship, we just,
Both sides, my lord, we had just handed over two names each. I think the
we
state
have
had given
handed a-
one name. We had given two names, my lord.
we had given a list of names, not only one name. That is on 14th May 2025, Your Lordship. This is the list of names. Yeah. I think this.
Where's the communication dated 10 July 2025
My lord,
from the Deputy Commissioner?
my lord, copy is here if lordship.
Wait 1 second. This is addressed to H. Abraham.
Yes.
Yes.
So, my lord, these were the terms and conditions which the state government had come up with. These terms, my lord, were further added to by my lord on 11th July 2025. If lordship kindly looks at that order.
You give a type copy and which copy is same? 1 second. (11 July), yes.
11 July, if lordship kindly looks at para 4 of this order.
Yes.
In consideration of the matter and urgency expressed and the conditions given by the state respondent so and so through the deputy commissioner and the undertaking given by the Dorbash norm so and so, it is therefore directed that the petitioner shall undertake the pilgrimage as per the conditions which have been enumerated in the communication dated 10th July 2025. It goes on, para 5, my lord. Though objections have been raised by respondent so and so in the pouring of water on the stone, to balance the equities and in the interest of justice, the organizer petitioner shall only permit a symbolic sprinkling and not pouring of water on the stone.
No, yes, okay.
So this was the additional condition that my lord had imposed. And as I humbly submitted on the last day, the sprinkling of water is causing discomfort, my lord. We are requesting for being allowed to pour water, my lord. Could be a limited amount, 500 ml, half liter each, but pouring.
Okay, now, are you agreeable to this same condition 10 July?
The terms and conditions
Yes,
may be the same,
Your Lordship.
but the sprinkling may be kindly replaced by pouring, my lord.
Who is appearing with Darbar Shnong? Yes.
On the occasion also, my lord, I expressed my objection with regard to permission. Now, lordship has given them last permission on the occasion and stopgap arrangement since the matter was pending. Now, exchange of pleading completed already. This matter can be decided by this order of court. We raised the question of immediate plea.
Last time,
Yes.
you have not, what to say, objected to the conditions laid down by Deputy Commissioner. Correct.
But at that point,
Then-
as a stopgap arrangement, we also
What is your
consented.
objection now?
But now the situation, the lordship, exchange of pleading is completed.
No,
That
no,
time, my
what is your, what do you call it, your
my prayer,
stand now?
Yeah, my stand would be, my humbly pray with profound respect. My prayer would be, lordship may kindly decide the writ petition on merit.
No. What is your stand regard to Yatra?
Yatra, my lord, we have objections. We're not allowed.
What objections do you
Confusion
have?
is going on, my lord, in the village. Confusion is going on in the village.
What confusion?
My lord, here, my lord, it is not a religious place. Now, what the
No, the thing is
petitioner
that
tried to establish.
Mr. Changreso, the things you have to understand is you look not only what you feel right now, what are sentiments right now in the village. You have to look at whether this has continued for how many years now?
Now, they claim in the writ petition, my lord. 16 years they continue.
Many years. Yes.
But that is a vermin in the writ petition, my lord.
Not a vermin. It's to everyone's knowledge.
Well, my lord, here, my lord, kindly
The thing is
appreciate.
that you cannot have one or two persons who entertain some kind of sentiments.
Yes.
If it's a peaceful thing, why should you object?
My lord, my lord.
Then
If the place is a public place.
you have to have what do you call it? This religious, what do you call it, tolerance also.
That
Not
is
a question
true.
of intolerance on
Exactly.
one part, and then that you do not allow another section of
Exactly.
people who maybe have reverence. So doesn't mean that you can just stifle their rights also.
My lord, Rangpa Shno
Now
has
where's
been-
the balance?
My lord, Rangpa Shno has.
Does those people understand where's the balance?
My lord, may I just say, Rangpa Shno has been projected in negative light by the petitioner that Rangpa Shno is against his freedom of faith and practice under Article 25-26. They have nothing to do with that. Now, in my garden, my lord, they end certain point of time, we allow them to reside
Now
and
whether
others.
you have jurisdiction over that cave at all also is
Oh, my
questionable.
lord, it is the ownership is with the.
Where's the ownership?
But no one claim ownership.
See, Mr.
Except the
Changreso,
petitioner.
if you want us to go there as regard ownership now, historically, how have you proven your ownership?
My lord, therefore, it requires a civil adjudication.
doesn't have civil
If they have a claim.
Now, if the CM
let them file a
Ram
suit.
at one point of time issued a memorandum which was accepted by the authorities, and these things were going on. Now, whether that land where that case should belongs, do you have any jurisdiction over it?
My lord, if lordship can take the pain to see the prayer made in the writ petition, my lord, it is purely civil dispute in nature. If they have any right over the
The thing
case,
is that now
they
is
should
different.
file a suit.
Now, last time you had all come here, the entire Darbar had come,
My lord,
right?
that is true.
And then
That is what
now can you change your stand from what you had last
No,
time?
that was a stopgap arrangement, my lord. In order to allow these people to organize the yatra, okay, since the lordship has seized off the matter, we will allow them with certain conditions. That is over. Now the writ petition is avoiding the final litigation. Try to obtain the permission this year also. Next year
It's
also
not
they'll take the
avoiding.
permission. This is
It's not a question
impermissible.
of avoiding the final adjudication.
But therefore, I impress upon my lord
My
to
lord,
decide
the-
Okay,
to
ready,
decide the
come ready
question
for
of
hearing.
ownership.
Yes.
Today is the
Today is
13th. You come for you ready for hearing on? We'll give you on 20th. We'll pass final orders.
My lord,
But-
my lord,
but
with,
where
res-
it-
with respect,
Writ is not maintainable.
with respect, my lord, the scope of the writ has increased because of the presence of the intervener.
Intervener, that's a
That
different
we have seen,
action.
we have seen.
We're looking at only
They have
one
no
of what
business.
was your main prayer here.
My lord,
Exactly.
because the intervener,
Segregated the other one for mediation.
because
Yes,
correct.
the intervener, my lord, has raised the issue of ownership also in the affidavit which they have filed. So until that issue is decided,
And
until that issue is
No, no, I've
decided,
seen that the state does not. There's no question. The state does not have ownership over that.
Exactly.
Not only thing. There's a dispute also between this aim
my lord,
Yes, yeah.
And the Shno.
and the Shinong also, and the organization which was issued a memorandum with represented by the petitioner person.
my lord.
Now, how do we tackle all that? Now, first and foremost is that Mr. Changreso has raised some objections. I want him to put those objections down.
Yes.
They put down in you bring your submission. Bring it on 20th.
Yes. I'll be
No,
ready.
20th will be not a good day because it's just
Monday.
no Tuesday.
21st,
22nd.
22nd.
Yes.
And the
You
constitution of
get
the,
your written submissions also ready.
and regarding the
My lords, I am,
constitution of the
my lords, I
committee,
am
your
appearing for
lordships.
respondent.
Yes.
My lords, I am appearing for respondent number 11 to 15.
You're a larger
The present
issue.
petition.
You're a larger issue. We will address
On-
that. Now we're
Yes.
just addressing the one that is eminent before us.
And I joined the request of my learned friend so far as permission to pouring of the water is concerned. It should be replaced by sprinkling. It should be replaced by
Now
sprinkling.
first we'll go work out the ground, the ground parameters. Yes.
I understand what is falling from this one.
Yes. Yes.
Item number 4.
Sure. On the request of parties, list as matter on 22nd July. As the matter concerns the conduct of the yatra and the objection has been raised by the Darbar-Shillong, parties are permitted to file their written objections to the matter before the next date. By Monday 20th, the matter will become 22nd. Positively, yes. We're not going to set the raise. We will pass orders. Yes.
Number 4, your lordship, we've taken steps to inform the respondent number 4, your lordship, regarding this.
Number 4 is whom?
She is the party who is
private
actually
respondent.
in place now.
So private
She
respondent
was
is number
appointed as the teacher,
4.
which has been challenged by the petitioner here, your lordship.
Number 4. Very good. Who's your arguing counsel? Who appointed? How was you appointed number 4?
Yes.
Number 4.
Number 4.
What was the illegality?
No, the illegality actually
didn't
what
have
happened
qualifying
actually.
marks. That is
yes,
what was the contention.
she got only below 45%.
Okay.
So I am top
Your
49.
name? You're working now. You're appointed.
Since January
appointed.
25, since January 25, your lordship. She's been
Okay. Yes.
working.
MCM. Ms. MCM has entered appearance today on behalf of the respondent number 4. And as such, notice of complete on respondents. If response allowed, 1 week's time for affidavit. Yes. Just thereafter. You file affidavit.
We have filed our affidavit.
They-
5.
His lordship. This regard for respondent number 11, we have taken the press step to issue notice to the respondent number, private respondent number
Number?
11. We have taken a step to issue notice,
Yes.
press notice. And then
1 second, 1 second. Not served by that. Yes.
the respondent number 1 to 3, I have received a notice of affidavit only today.
Yes.
So I may be allowed to file a reply to the.
What are you saying?
They have filed the affidavit.
Today, it's not on record.
We just filed today, Your Lordship.
In terms of the last order, the City Council were supposed to file a preliminary objection.
We have filed, Your Lordship. Yes, Your Lordship.
To that, Lordship is saying.
Oh. No, as I'm saying, it's not on record. Is it? You filed it just today.
Yes, Your Lordship.
Yes, and after it has been filed by response 1, 2, 3. Stop, Mr. P. Sangma.
I may be allowed to just file a rejoinder to the affidavit.
The priest will have to file a short rejoinder or long rejoinder?
Long rejoinder.
Rejoinder to the affidavit. Stop. What about you?
Lordship, I'll wait 2 weeks time, Lordship, for affidavit, Lordship. I'm appealing for respondent number 5 and 7.
When you will file within 1 week?
Lordship.
Yes, Mr. Chanda for 5 and 7.
Lordship.
Pray for further 1 week's time, which is allowed. What about 6?
Mr. Deb is on leg, Your Lordship.
So, if it's on leg or not on leg, what about number 6? Any affidavit necessary?
We haven't filed, Your Lordship.
6, 8, 10, 12 to 14? Please come with full instruction here from the same chamber. Saying it's on leg or 1 leg or 2 legs, we don't know. Who's appearing with the respondents? You are SDEP is appearing.
Yes, he himself, Your Lordship.
For 6 to 8.
6 to 8 years.
Oh, they've not been served, I think, Mr. Sama.
The last order, Lordship, has the
Yes, 8, 6, 8, 10,
8, 10, 12 and 14, Lordship.
14.
Okay,
Up
take
here,
on
right?
me. On behalf number 6, none appears behalf number 6. Record that. Then after that, status of service of notice upon respondent 6, 8, 10, and 12 has not yet been filed on behalf of the petitioner. And it's also noted that ED card that be received on behalf of respondent number 11. Just up to 2 weeks, yes, for rejoinder, affidavits, and for appearance of the other parties. Yes.
Lordship. Much press, Lordship.
Item number 6.
Wait, please, Your Lordship. Your Lordship, I'm praying for 2 weeks' time to file our affidavit.
You already prayed last time.
Your Lordship. Your Lordship, we're awaiting some clarification from
Last
the
time I
department.
Lingua prayed, now who's praying? Yes. The matter was filed when?
25, Your Lordship.
25. Now we're in July.
Your Lordship, this matter had gone for mediation as
Yes,
well.
but since last year, from November,
Your
it's gone for affidavit. Yes, it's noted the matter has been filed since 2025. Since the officers won't file since note down here. Since 22/7/2025. Stop. A year's elapsed and no affidavit yet on record, so the matter had also gone for mediation. Accordingly, it's expected that affidavit should be on board within 2 weeks positively. If it fails, we'll ask the officer, let him count the records.
7.
May I please, Your Lordship, in this matter we are supposed to file rejoinder, Your Lordship.
Yes.
I'm praying for some 3 weeks' time to file
My lord,
rejoinder.
I have some objections, my lord. Because we have filed this affidavit on the 15th of May, my lord. Since back then, we have asking time and time
How many
again.
times? This is the third time?
This is the third time.
Give her one more chance. Yes, third and final opportunity.
3 weeks' time.
Allowed.
3 weeks' time, Your Lordship.
No. 2 weeks time enough.
Obligation.
Give you final opportunity asking for 3 weeks time.
8.
Yeah.
Your Lordship, in this matter, item 8 and 9 are connected matter. Kindly grant me 2 week time to file for rejoinder affidavit.
The first prayer?
Yes, Your Lordship.
Yes. What about number 4? The file. Your name?
Bala Plilat Bala. B Bala.
V Bla.
B Bala.
B Bla. We have prayer sponsor 2 weeks time to file rejoinder.
Much obliged, Your Lordship.
10.
Yes. Also the petitioner and Sinkon. In Sangma. Correct? Yes. I have not filed.
Lordship, we file our objection to the application for impleadment, my lord.
Where's the objection? There's a miscase.
Yes, Lordship. So the matter is yet to be heard on the objection, my lord.
Objection. What's your objection?
Our objection is mainly that it will result in multiplicity of cases, my lord, and there are a number of civil suits pending before the trial court.
Where's Mr. Sinkan?
He's on next, Your Lordship.
We'll take it after some time. Call him.
Obliged, Lordship.
Call me after some time. Huh?
11.
May it please, Your Lordship. The private respondents are yet to file their affidavit now.
I prefer some more time, Your Lordship.
What's the matter about?
This is a Nokma matter, my lord. I am aggrieved by the action of the district
You've been
council.
a private respondent?
Uh,
For GHADC?
GHADC and private, Your Lordship. For GHADC, we have filed the affidavit, Your Lordship.
You are paying for and for the private also?
Yes.
That means there's collusion in the case.
For GHADC, we have
You
filed.
understand the implications? No. It's okay, yes.
Much obliged.
Take down a number of place funds allowed for the 2 weeks time will be have by respondents 4 to 6.
4 to 6. Much obliged.
Order is not over, so she's already anyway. Yes.
12.
She will quote the act matter, my lord.
Where's the affidavit?
Yes, my lord. We need some more time now. Possibly in next couple of weeks we will resolve this issue. If necessary, we will extend the act also, my lord.
Yes.
Because that is the issue which is affecting throughout Meghalaya. Constitution. So, you ultimately give 4 weeks time. We will take it to cabinet or if necessary. We will get the act extended.
Well, Advocate General paid for 4 weeks time as the matter is. What is under policy scrutiny?
Yes,
13
also connected.
14.
Your Lordship.
Yes, Mr. Sam.
Kindly accommodate 2 weeks more because
Why?
I'm yet to get in contact with my client.
Where are they staying?
They are in West Garuhil. They will be coming this week
Very good.
to discuss.
To discuss first, not to file affidavit, not to file agenda. To withdraw.
To withdraw or otherwise we will discuss, sit together.
Very interesting matter. But what do you discuss? What will you discuss?
We discuss, we have advice, different thing whether to file civil suit under, whether it is
Keep on
under
sleeping.
DB, under DB, or whether
Under
to withdraw, yeah, domestic violence act, all those things.
You have not got a property also.
No, Your Lordship.
Not enjoying it.
But he is enjoying the property.
Order was directed to hand over the property.
What property you enjoying?
This is a self-acquired property.
What property you enjoying? Your property only.
Yes, Your Lordship.
He does not, according custom, he does not have self-acquired property as of now, Your Lordship.
And this matter, very vexed matter anyway. Let's have 2 weeks on the prayer of Mr. Elam Sama. Nothing will come out.
Yes. Highly obliged.
15.
Your Lordship, this is a transfer petition in relation to the divorce proceedings instituted by the respondent.
May I please,
Where's the
Lordship?
rejoinder?
It won't be necessary, Lordship.
Yes.
Some more time, Lordship,
For
hearing, Lordship.
This matter can be disposed of today.
transfer only, we can dispose of today. Where's British? He was just here.
So he's engaged in another call, Lordship.
We call him now. He was here just now.
After some time, Lordship.
We'll dispose it off, yes. Transfer petition. You're the wife.
I'm the wife, Lordship.
Yes.
16.
These are 16 and 17 for appointment of arbitrators, my lord. Now, we, on the last occasion, I have suggested that any retired judge can be appointed. Now, they've given names from Punjab, Haryana High Court.
Four retired judges.
They've given, we have no reasons to.
Who are those?
They are retired High Court judges, Lordship.
Why Punjab, Haryana?
But what I would propose is somebody from Shillong or from Guwahati.
Lordship, we have no difficulty, Lordship, because nothing has fallen from senior Lordship.
Yes, what means you shown?
Justice Kuldeep Singh, Justice Rajiv Sharma, all from Punjab.
Or generic names also.
Same one.
Just one thing. Okay.
Justice YP also can be appointed.
What's the amount?
Lordship, the amount is 2 crore 60 in one item number.
Yes, small arbitration matters. I think in 2 sittings they can be finished.
Any council, if they're agreeable, can be appointed. Can get some exposure also.
These are Lordship little complex issues because Lordship military engineering Lordship expertise will be required. So Lordship, I would suggest if retired High Court Judge Lordship.
Better than he can take assistance, yes. Lordship. They will appoint just YP only since he's
both the
close by.
Lordship.
Yes.
Item number 16 and 17, Lordship, are similar, Lordship.
Then counsel for the party suggests and the support have agreed upon Justice D.Y. Pei being appointed as the sole arbitrator, which is free to obtain consent before the next date. This thereafter.
18.
This is again, Lordship, arbitration matter, Lordship, where on the last occasion, Lordship, we had agreed upon Mr.
Yes, has he given consent?
Lordship.
Yes, we'll pass all this.
Lordship. I'll leave, Lordship.
You-
19.
Questions here? Mr. Marpan, you're for the petitioner?
No, I'm for the respondent, Lordship. I have filed a miscase, Lordship, applicant for striking of the name of the applicant.
Who's objecting? You objecting to it?
No, Your Lordship.
You're for the petitioner?
Yes, Your Lordship.
What's your objection?
Okay, file the objection.
Your Lordship, kindly have this matter after 2 weeks because my outgoing counsel is on leg in room 1.
He'll be on leg for 2 weeks continuously.
We can have it after some.
Kindly.
Sometime, yes.
Okay, much obliged, Your Lordship.
That'll be world record, yes.
Twenty.
Make reasonable prayers, you know this. Just seniors should teach juniors to make reasonable prayers. If you're on, what happens if I'm on legs? What happens if I'm not available momentarily? What happens if I'm indisposed? What happens? You know, that is the kind of instruction you give. Not go and ask for 2 weeks' time because I'm on legs.
Lordship is right.
In item 20, Milords, we had to file an affidavit. Milords, but I have been told that the officer concerned is Milords under some medical treatment, Milords. So I'm seeking some more time, Milords, on this matter.
Just regarding?
My lord,
It's a contempt case
my lord had passed a judgment directing them to consider my representation within 4 weeks. They filed an appeal against that. Division bench did not find any merit in the appeal, gave them 6 weeks to consider my representation. 6 weeks, my lord, got over in March, middle of March.
1 week, yes.
Obliged.
On a premise, yes, Pandey, let the matter appear for 1 week. Yes.
Milords, may consider allowing us 2 weeks for disposing of the representation.
We'll not pass the
And the
all
matter
time
can be
application. Whatever you do in the intervening period is entirely up to
Yes,
your own convenience.
21.
Yes.
But I am praying for a little more time, my lord, for affidavit.
Lordship, respondent 3 also yet to enter appearance, Lordship.
1 second.
My lord, we received one letter, my lord, from the...
You are appearing for 1 and 2.
Yes, my lord. Now for the NCC...
But then you already submitted inconsequential.
Yes, my lord. No, of course, all the appointments and all that...
Last time I said that 1 and 2 inconsequential.
My lord, 1 and 2, all the appointing authority is 1 and 2 only, my lord. For the requirement of the NCC, my lord.
And number 3?
Number 3 is the NCC office, my lord.
Is the?
Is the NCC. The appointments, the administrative staff is all managed by the state, my lord. So appointment is by them, and the NCC officials are from the center, my lord.
So who's appearing for 3?
For 3, my lord, we were asked to inform the NCC, my lord. We received a letter.
Lordship, in fact, on 5/6/2026, Your Lordship had directed respondent number 3 to engage a separate counsel.
Yes.
Lordship, that was the order, Your Lordship. Direction.
You're in contempt this order also.
So, my lord,
yes.
This is the letter that we received, my lord. It says their administrative staffing and their salaries for NCC unit and group. If I just
No. Engage separate counsel means what?
So I asked them to engage.
You
a
asked them
separate
from
counsel.
5/6 it was instructed.
We already informed them. Also,
and your colleague has said that
Yes,
1 and 2 you're not going to file, you're inconsequential.
No,
So
my lord. Affidavit we have prepared.
Then
We have
why?
received.
Then this have to withdrawn this submission made by your by the state.
I had said that 3 is the main respondent because they were the appointing authority.
As per the instructions, all the appointments are done by the state, my lord. If my lord kindly sees the order also.
That,
yes, I understand, my lord.
Sarji,
My lord.
That's what is required is to put on record anything that you have to say.
Yes, my lord.
There's a question as who the vital respondent.
My
maybe
apologies,
vital
my lord.
number 3 and 1 and 2 unconsequential. That means no affidavit forthcoming from them. Correct. You wish to file affidavit or not?
My lord, if it goes that way, of course. My apologies, my lord.
Not goes that way. So, instruct counsels how to
And
go about
NCC
the
is the main
case.
respondent because the
What submissions to
prayer
make.
is on for the NCC to release the payments. Prayer to देखो.
In spite of the order dated 5/6/2026 and 23/6/2026, the respondent number 3 appears has still not engaged a separate counsel to represent them. Further, Mr. K.P. Bharat counsel 1 and 2 submits that submits that respondent number 2, contrary to submissions made earlier, required to file an affidavit. It was not understood as to under what instructions it was submitted last occasion that 1 and 2 are inconsequential. However, in the interest of justice, for the 2 weeks time allowed, don't to file affidavit and for respondent 3 to engage separate counsel. And we'll have to drop proceeding.
My lord.
22.
Lordship, show cause to the miss case filed by the respondent number 4 has been filed, and also rejoinder to the affidavit filed by respondent number 4 has been filed. Left is district council to file.
1 second. Sorry. What the miss case about?
This case is regarding modification
of the stay order, Your Lordship.
Modification, alteration, vacation.
Now you filed your rejoinder to the main affidavit of firm number 4.
Yes, Lordship. Already.
Correct. Number 4, Ms. S. Karim. 1 and 3, you haven't filed till now.
I have filed an application for implement. They are yet to file show cause to my.
That will come later. The order is already passed, Lordship. Last order is.
We're in the miss case.
Oh, there's another miss case, Lordship.
How many miss cases are there?
My miss case are 3 miss cases. Lordship.
There are 3 miss cases?
Yes, Lordship.
Now miss case Mr. Karim, which number?
135. My miss case,
Number?
135, Your Lordship.
135.
My miss case, Your Lordship. In WPC 158.
135 is a miss case. In pleading, which number?
In pleading is 157. Lordship.
135. The next one is 157.
157 of 26.
That's filed by Mr. Shilla.
Yes, Lordship. That an order has been passed just to keep in abeyance. To keep this matter in abeyance regarding impleadment. Order is already passed. Last order.
No. 135 is miss case filed by
me, Your Lordship.
Respondent 4.
157 is by you. And what's the next miss case?
That is a miss case interim order, Your Lordship.
That is number?
With the main writ petition. That is 120. Lordship.
Your pension yes, your pension langs imyong.
Yes, Your Lordship.
Yes. So what is your ground for vacation? What is your ground for vacation? Because the finding of the court was that section 9(2) is provided that no acting CM shall be appointed on recommendation of the CM plan. Correct. And then there are no materials to show the recommendation received from CM plan.
Question of fact.
And as such, on that point, interim also issued.
Lordship, we are saying it's a disputed question of fact, Your Lordship.
Meaning?
Because to decide like which recommendation is valid, Your Lordship, that has to go before the district council, Your Lordship. It's a disputed question of fact, Your Lordship. And as such, section 9 is very clear.
Which paragraph have you made that amendment? That's disputed question of fact, and we don't know which CM plan to give recommendation. Where is that? That is your case, right? He got no recommendations were given by the recognized clan.
Because there are two
recommendations. There are recommendations which was given to us in the month of November 2025. That recommendation was never considered, nor it was rejected. But respondent number 4 was, after that, some recommendation was filed by some group of the Simyong clan. Immediately within a period of just 1 day, he was appointed. Despite the fact that the recommendation is already there.
Where have you stated that in your application?
Paragraph 3, Lordship. Paragraph 3 in my paragraph 3, Lordship.
Paragraph 3?
Lordship.
No, where regarding your recommendation, where is that? Maintainability is different thing.
Para 8, Your Lordship. My recommendations are para 8, Your Lordship. Lordship, here, Lordship, there are two connected, Your Lordship, in this matter. And the next item, Your Lordship, petitioners are yet to file their rejoinder and objection to the miscase, Your Lordship.
Objection to miscase, but this one,
Your Lordship, a common order was passed into imported petition, Your
so
Lordship.
this will suffice, will answer both of them, correct?
I'll be requiring to file a separate rejoinder.
Why?
Item 159.
Why would you file?
Who is the...
You're the same person with Mr. Marpan.
No, Your Lordship.
No.
158 is the...
Same, I mean, same cause of action. You are, what do you call it?
I'm from the
Kur. The same cause. From the Kur,
yes.
And your person. You're the person who's been recommended by Mr. Marpan's clan. Correct?
Yes.
And Mr. Kriyam is for
the
newly appointed. The newly appointed has been stopped now from functioning.
Yes, Your Lordship.
Yours is recommended by Mr. Job. No, by Mr.
He's
Chilla.
another group, okay.
Actually,
by whom?
Actually, my lord, what has happened, my lord?
Who are you?
This course Imyong, my lord, has 3 Khwa, my lord. I am representing 2 Khwa. The one which Mr. Marpan is representing is represented only by 1 Khwa. And they are misrepresenting before authorities that they represent the entire clan.
So who's recognized by this aim as the rightful? Who's recognized by the council rightful?
We are registered also.
Yes,
as of now, they have got.
Who's recognized?
We are saying that they are the registered clan, so they
registered clan
should be given due importance, but that is not as per the act.
We have
the registration is only for the purpose of the village act.
Well, if I may, it's the only authority which can then determine this issue as to who would be the rightful claim. As it seems, well, it's their contesting claims, would be the district council.
Right, of course.
No,
I just want to know. Now, you're saying you're having 2 clans. Both Imyong clans.
2 Khwa.
Okay.
Yes. And they are.
And he's 1 Khwa.
Yes. And they're claiming themselves to be the entire clan.
Why not?
No, because our confidence need to be taken into consideration. We are also part of this.
So in the earlier consideration for recommendation, who makes it? All of you three four together.
Judge, I have to
Then what was the practice?
No, usually the entire clan has to give recommendation. The
Then
Act says the entire Imyong clan. And in fact, my lord, this genealogy is there in the Act itself, my lord. In the Act itself, they have mentioned what are the Kapor, my lord. And by their own admission, they are presenting only one Kapor.
Okay, well and good. But the thing is that what was the practice? That's what the court also was.
The practice is to recommendation is mandatory.
So now what is status of registered clan then?
Yes, sir. Annexure 1, page 11 of my record.
No. What is the effect of registration then?
Let's say, I mean, my humble submission is it will not have any effect per se.
Even for that,
That's something that's
registered.
Even for that, we have already given our objection.
No, are you registered also?
No, my lord, because that has been done behind our back. On coming to learn of that, we have
then they should have filed an objection and maybe for cancellation before the district council. That was not done.
That matters before the
for cancellation of the registration as the only
that should have been done.
We have
that was never done
before the district council.
No, have you now they have a registration in their hand, correct?
Yes, sir.
Then
there was never challenged.
We have challenged that, my lord. We have.
This is issue with district council.
We don't see it.
My lord, we have submitted before the district council, my lord. We have submitted before district. The matter is still under the consideration.
As per the registration.
This is from Langren.
Yes, my lord.
Yes, sir.
So who controls the land then? There are two main EM there. Who controls these two lands now?
My lord. So far as this issue of land is concerned, my lord, there's already a suit 1990 settled.
1990, yes, we know.
Between the Hima and the Hima and the Imyong clan, my lord. Joint ownership of both the Hima as well as
and the clans. Yes, which clans control that now? Which clans control that now?
Now there's a management board.
Clan, that's what I meant.
Which Imyong? That's why I'm asking this question. Which
Imyong clan would be?
We are controlling it.
In fact, before registration.
See, in Langren there are two main, they're like mother loads where the entire coal situated. One is called Pendeng Tangle and the one is called, and I've forgotten.
Yes.
Yeah. So that a fight between the clan and this EM since historically was over control of these two. They're like the El Dorados of Langren clan or the Langren's EMship. Okay. And so in Langren's EMship is one of the few EMships where they have for election was EM by adult franchise also. And so that case is between, yes.
We are controlling the land, my lord. So now they want to control
the management
land.
committee. I know after that case was done, whatever. But
now
then
they want to control.
I just want to know now who's Imyong clan that is in the management committee controlling it. That will be the real Imyong clan then. You don't have anything.
No, we have a document. Now Annexure 1 of page 11 is a registered document issued by district council.
Now what they are doing,
they're not even registered
on that.
Now what they are doing, your lordship, it's through this being an acting.
We'll do one thing. You file your agenda, we'll dispose of one shot next day.
And also,
we send it back, yes.
Because I have filed an application seeking modification of the interim orders passed by my lord.
We will not disrupt that.
Exactly.
It will be 1 week or 2 weeks affair.
In that case, this case will be disposed of.
No, we won't dispose it, we'll dispose all together.
Can be disposed of together, my lords. The entire matter can be disposed of at
once. The thing is that the court can't sit here to determine who's Imyong clan 1, 2, 3. That be done by.
The district council would be the competent authority.
Yes, Lau Langam Tila and Pendeng Tangle, they're two like mother loads. Yes. Yes. You're aware of that, no?
Yes, ma'am.
Yes, on the prior MSPS Nongbri and Bihar response number 1, 2, and 3 for the 2 weeks time granted for affidavit stop. It is material affidavit should be on board before the next date, where an endeavor shall be made to dispose of the entire matter along with connected business applications. The next matter also, the jointed will be filed within 2 weeks. Yes, list together.
That's interim to continue.
Interim order to continue.
Item number 24.
Service is complete.
We have taken Dusty.
Lordship, I am appearing for respondent number 2 and I require 1 week's time to file affidavit.
What about number 3?
Well, we've taken steps, we've filed an affidavit, my lords.
Yes, no appearance, we recorded that. You are appearing from, who's this lady? IPN number 3.
Lordship, I'm appearing for the respondent number 1, the chairman.
Yeah, MSA Boro.
Yes, Lordship.
Okay. Yes, MSC. Have you filed affidavit?
Yes, Lordship, we have already filed our affidavit.
Very good.
One has filed.
MSA syndrome for 2. 3 and 4 are for
completion
a
of
week's
the
time. File affidavit. Noted that though the respondent number 3 has been served with no appearance till date. It's a 2 week for affidavit number 2 and for appearance of number 3. Yes.
That's interim may kindly continue.
Interim orders we need to continue.
Lordship, matter may be kindly listed on 23rd of July.
Very good, yes.
25.
Wait, please, Your This is not the pharmacy council matter. The pharmacy council is existing. What the petitioner is saying, he himself was member of pharmacy council for 27 years. So he has approached your lordship for direction to the state to hold election of pharmacy council. The term of pharmacy council of the constitution is slightly different. I'll put all these things in affidavit. Kindly give me some time. I've gone through the matter more. Instruction has also been received in this matter with quite distinctly. Please file the affidavit in 2 weeks.
Number 4. Who are you representing? Private person. Yes, General Fund 2, 3 and Assembly for 4 pray for allowed. Further 2 weeks time for affidavit. At least thereafter and so on.
26. Your Lordship, I pray for 2 weeks, Your Lordship, to file an affidavit.
Correspondent 456, Your Lordship.
You're the same chamber also? Yes. 2 weeks further time to respond for affidavit, yes.
27.
Wait, please, Your
May I
Lordship.
please, Lordship.
Your Lordship, I'm praying for some more time on behalf of respondents 1, 2, and 3.
My lord, yes, my lord. Private respondent number 4 and 5, we received the status report.
You file affidavit?
Yes, my lord, we'll file affidavit.
MSZ nobody pays funds allowed further 2 weeks time for affidavit.
My lord.
Mr. SK Hassan next line submits that status of service with respect to response 1-4 has been received. He pays funds allowed to put a service affidavit on record. Yes, it's up to 2 weeks for affidavit for appearance of respondents 4 and 5.
My lord.
Obliged, Your Lordship.
Hello, please.
28.
But we are unable to receive instruction from the council. 2 weeks time may be given.
From the council?
Interim order statement. This is with regard to delivery of impugn order through WhatsApp message.
That I should just take correctional steps.
Yes. What happened, my lord? The message processor of the council went to the village to deliver the copy to him. He did not find him, so he found another friend. He handed over the impugn order to his friend, and his friend has sent the impugn order to him through WhatsApp. Yeah, we take the responsibility.
But that's good technology in village also. Yes, sir. You're appearing for whom?
Respondent number 5, Your Lordship.
Private respondent.
How much time, Mr. Chandra?
2 weeks time.
Mr. H.L. Kang, we were so learned senior counsel with MS Hajong.
Appearing for 1 to 4.
And also, what is your name?
Kestan, Your Lordship. Kestan. Kestan.
S-T-A-N?
Yes, Your Lordship.
Yes. 4, 5, 3, 4, not for the 2 weeks time for the affidavit. Interim order ready to continue next day.
Second call, item number 10.
My lord, I have filed an impleadment application, my lord, to implead the owner of the land, my lord, as a...
Who's owner of the land?
Respondent party, my lord. They are Joaquin Kurkalang and Stonley Maniksi, my lord.
Thing is, Mr. Sinkan, you're dragging it to it's a civil dispute. So what do you, by dragging them,
No, my lord,
what do you achieve?
Here, my lord, I am only challenging the order passed by the Deputy Commissioner,
How
my
will you
lord.
assist you in the case? How important are they?
Now, my lord, if my lord will see,
your main prayer is with regard to?
To set aside this order, my lord, 7th August 2020. 2025, my lord. This order is, my lord, entirely arbitrary, my lord.
So we'll stick to that with
Yes, my lord. Page number 14, my lord. Entire order is arbitrary because, my lord, Article 300A, even though right to property, my lord, it is not a fundamental right, my lord, it is still a constitutional right, my lord.
You're building on forest land.
No, my lord, this is private land, my lord. Now, in terms of Article 300A, my lord,
Where's the rejection of your, after they issued you this?
My lord, they have directly issued me this.
What step do you take after that, Mr.?
My lord, I have approached the authorities, my lord.
Yeah.
And in fact, my lord, I have already constructed the building there. And I have also enclosed my building permissions, my lord, that is page number 12. Then I have given one representation, my lord, page number 13 to the Deputy Commissioner, my lord.
You answer it, you disposal of?
Yes. My lord.
No need to complete.
My lord, exactly.
Because you see, the thing
It
is
can
that,
be disposed of,
see,
my
the
lord,
thing is
without
that, see, there must be a civil suit or something.
My lord.
There are other proceedings, like government revenue land, just...
My lord, my only concern is, my lord, even for a moment, my lord, we take it as a government land, my lord. Whether government has the right directly to go and throw the person who is in occupation of the land, my lord, they have to follow the process, my lord. Now, Article 300A, my lord, clearly says.
See, the thing is that, listen, now you come and notice immediate stoppage of construction. You go before the revenue authorities, they have issued orders.
Now, one aspect, my lord, one title suit, my lord, is already pending.
Exactly.
Now, if they have to do anything, my
lord,
lord,
this court's going to.
Yes.
Now will change whole character of the suit.
No, my lord, that is a different proceeding between two different state as well as
if your land is
the party.
situated, if your construction is raised in the suit land itself,
That is, my lord, outside that is as per my
so then you
submissions,
make
my
that
lord. That is
prayer
outside.
the
I
suit
have
land,
already made, my lord, that does not fall under the Pirda state, my lord.
Take down here the petitioner who claims to be the owner of a plot of land measuring area about 6105 square feet situated at Lumpeding, Upper Shillong, allegedly purchased on 6/3/2021 from one will not write from whom. So before this court, assailing an order dated 7/8/2025 issued by the respondent number, which one? Number 2, bracket jurisdiction East Castle Hill, whereby he has been directed to
stop, my lord,
ongoing on construction. Mr. N. Sinkon Nakvara, Council Petitioner, submits that the action of the respondent number 2 is without any authority and illegal, inasmuch as a valid building permission / sanction has been received from the Office Executive Committee HEDC, after which the construction had commenced. He therefore prays that appropriate orders will be passed for quashing and setting aside the impugned letter. Learned Singh advocate on behalf of the state. You see this in government land, right?
My lord, revenue land lordship.
Has maintained, has submitted that the notice itself would reveal, the impugned letter itself would reveal that the petitioner has been directed to stop ongoing unauthorized construction on government revenue land, being Prada Estate at Karma Perchalong. She therefore submits that this being a revenue matter, the petitioner has alternate remedy to pursue before revenue authorities.
My lord, my only grievance is against this order, my lord. The Deputy Commissioner is not in its capacity to pass this order, my lord.
We will allow you to raise that. Yes, this court has But submission length of the parties also perused the impugned order. Stop. Though the grievance with petitioner with the authority for the respondent number 2 to issue such orders as it would as it would amount to. What is the submission?
My lord, it amounts to violation of the right guaranteed under Article 300A, my lord.
Amount to a violation of right guaranteed in Article 300-A. In the consideration of the court, as it involves disputed questions of fact, especially with regard to the location of the said plot of land, the person should be well advised. This would be better served.
Direction may be given, my lord.
If appropriate petition is made before the revenue authorities.
If I can suggest,
particularly the Deputy Commissioner Revenue for examination of the matter, is made clear that the petitioner is at liberty to raise all issues which have been canvassed before this court today. It is expected that the matter should be taken up and addressed by the deputy within a period of 6 weeks. Yes, from the date the petition is filed. Complete the petition is filed. With the above.
With liberty, my lord.
That's liberty is always there. As ordered above, the matter is disposed of. So all pending applications also just then close and dispose of. Yes.
Obliged.
Much obliged, my lord.
Second call item number 15.
Your Lordship, still says engaging in another court, Lordship. Let this matter be taken up to 1 week, Lordship.
Where is he gone?
Yes, court number 1, Lordship.
Court number 1?
Yes,
Lordship,
Lordship.
the agreements made in the affidavit are all on merits, Your Lordship. And moreover, in matrimonial disputes or matrimonial matters, the convenience of the voice has to be considered, Your Lordship, rather than the inconvenience.
You want transfer from Tura
from Shillong to Tura.
From Shillong to Tura.
Lordship.
So you tell your client to take instruction that courts of the tentative view that the patient be allowed. Okay. Take instruction 1 week. Yes.
They come on Friday, Your Lordship.
Yes, MSGT Sangma.
GCH
GCH Sorry, GCH Marak. Keep on. On the observation of the court, pray that you allowed 1 week's time to obtain instructions. Just a matter after 1 week. Yes.
Second call item number 19.
Yes, my lord. This is my reply, my lord. I have filed my reply to the deletion of the bank manager as a party in a personal capacity.
Yes.
Yes, my lord.
Where is your reply? Yes.
Yes, my lord. My lord, this is that I...
1 second. Yes.
My lord, I would refer...
What is your main objection? First objection?
My first objection is that, my lord, I had gone to the bank, which is... My lord, I have...
First objection to him being struck off.
Yes.
What's the first objection here?
Yes, my lord, I will refer to paragraph number 14 and 15, my lord, of my... I'll just read. You don't need... Not necessary for my lord to go. I'll read.
Look, can you just...
I'll sum it up. I'll sum it up, my lord.
No need to read. Just, what is the first objection?
My first objection is, my lord, I had gone there physically. I was present in the bank physically.
No, what is his role?
His role there is, my lord, I had told him, physically I was present in the bank, I had told the bank manager that...
fixed personal liability on him.
Yes, my lord.
That's your case.
Yes, my lord.
Then we reject your application.
But my lord, my lord, the thing is...
My prayer is not to delete him completely. It's just the name while maintaining the designation in the nomenclature.
No, she's alleging malafide against you.
Yes, I am, my lord.
The objection doesn't say anything like that.
But my lord...
Apart from saying that it is essential for complete and effective adjudication.
My lord, there were two instances...
personal remark, nothing.
My lord, there are 2 instances where I have...
All the communication happened in the bank. It was the branch manager who had helped her. Obviously, it's a customer. He has to help the customer.
But my lord,
I have informed the bank. Was also, he was the one who had helped her.
Well, you only delete by name only.
Just by name only. But the nomenclature and the designation will remain.
My lord,
because this is a transferable job. In fact, it will help the petitioner if his name is not there.
But my lord,
Because
he
the liability will lie
personally
on the
knew that these
designation, Your
transactions happened, and the thing is, my lord, he could have stopped. There could have been two instances where he could have stopped.
That
The
is,
first
if
instance
you
is
did not
when-
stop also, it was because
So
of
you
the
attribute
designation.
any, what do you call it, culpable action on his behalf also? That
Yes.
that he assisted in effecting this fraud.
No, I'm saying, my lord, that he was informed, my lord, but he could have stopped. He could have blocked
Inform
these
us
things,
as
but he did
branch
not.
manager.
He did not do any of those things, my lord. He
If
kept
he was
quiet.
Whatever act, whether
he was
rightly
complicit in some manner, then yes, maybe.
Yes, my lord. May I read, my lord? The thing is, my lord, there were two instances when I had gone back to the bank saying that why is it that despite the fact that I have told the bank that two beneficiaries were added to my account, which I do not know who these beneficiaries are. I
And he
had
said
called
it's
up, I got
perfectly
this.
all right.
He said it's okay. He said, why have you come? He said, I do not know. He said, we will try to help you. And then he said these transactions were confirmed by phone and email. I never made those phone calls. I never confirmed in the email.
What's going for the state? What does cyber crime have to say?
It is still under investigation, Your Lordship.
When was this petition filed?
This was filed in the this year in the month of February.
No, it was not in the memo of Feb. It's on the 11/8/2025 where an FIR or this writ petition. February, my lord. I'll tell you when this was filed.
So you see, he personally implemented for his own personal act.
Yes, my lord, because he had sat with us. We sat together, we explained, we were together in the bank, my lord.
As a branch manager,
these things
as a
were
branch
taking-
manager in the bank, all the
And
transactions.
my lord, he
happened in
drafted the
bank.
FIR,
Well,
and
rightly,
my lord,
wrongly,
he could
has
have
done-
stopped the transaction. There could have been a hard block.
Maybe next bit is be more careful if they are made by name, not by designation.
If I may, my lord, it says that.
Right? They'll be more alive to the situation, and take extra care.
He will definitely,
If
as
they
a branch
drag
manager, also
personally.
in person. I'm in fact saving the petitioner because if his job if he gets transferred, he will not be there. He'll not be held liable.
But
So
then my
the
lord-
branch manager will be held liable.
The next
He
branch
has-
manager.
My lord, my lord, there are evidence that
My
that
affidavit
have
is
been
also
whole.
pending, Lordship. I need to file an affidavit. So this thing has to be clear. It has to come by
You file
designation.
a affidavit.
Yes.
We will not allow your prayer. Stop. In the objection filed by the petitioner to striking or deleting of the name of respondent number 3. Stop. Mr. S. Marpan has submitted that he Mr. submitted that the job held by the respondent number 3
4.
is transferable, and there's no necessity by impeding him in name, and in fact will assess the case of petitioner in the event he is transferred from the present post of next para MS OI Bank, however, has vehemently objected and submitted that the said respondent has been impeded by name in view of the fact that in spite of her personal appearance or personal interactions with him with regard to the addition of certain beneficiaries, the said officer had not taken any proactive action.
And also, my lord,
which
he had
has
threatened my.
resulted in grave loss being caused to the petitioner. She therefore submits that he be that the petition for striking of his name be disallowed from this court on his submission of the parties, and also the objection raised by the petitioner. Notes that as a matter deserves further consideration as the culpability and liability of the said respondent in person or by office, at this stage rejects this application, and
3 weeks. 3 weeks.
rejects on this application. Stop in the main case. Mr. F. Marpan pays funds allowed further.
3 weeks.
3 weeks time to file affidavit. Next by MSS Lalu on behalf of respondents number
My
1, 2, and 3 also praise that leave out some time to file a status report with regard to investigation. Yes, this up to 3 weeks. Yes.
My lord, he had threatened.
Hearing item number 29.
Wait, Miss Case, wait. And the main case going.
Please, Your Lordship. Lordship, I pray that this matter be placed at the end of the court.
This matter is regarding that limitation.
Yes, my lords, your lordships, that section 11 application, your lordships had heard us. Only my friend was supposed to respond to that judgment, my lords, by the 7 judges of the Supreme Court.
He's ready in the matter today.
Yes, Your Lordship.
He's ready.
Very well, ma'am.
You won't come and ask for time.
He's still engaged in court 1, Your Lordship. After some time.
Yes, after some time.
Very well, ma'am. End of the board. I don't think too many matters are left.
Yeah.
30.
May I please, Your Lordship? Your Lordship, the arguing counsel is in court 1. May it please at the end of the board.
Where's the municipality?
She's here.
Shillong Municipal Board or
I'm for the respondent 5. She's
Yeah,
for
yeah.
the municipal.
Your Lordship, Mr. Day still unlike Your Lordship. Your Lordship, I seek accommodation. Let it come next week, Your Lordship.
Only one thing regarding Charter of Duties, correct?
Yes.
Has it been provided to the court?
At the end of the board, Your Lordship.
Where's the arguing counsel? You also
In
not
court
here,
1.
and they also not there. Then, so you two start arguing. You want to keep it on the board.
She is here, Your Lordship, in court 1.
It's Monday. We'll try on Wednesday.
Yes, Your Lordship.
Yes, as both arguing counsels, as arguing of both sides not present, this is the matter on Monday is or Wednesday.
Of lunch.
31.
This matter on the last occasion was in the order, my lord.
Order, Lordship.
Awaiting rejoinder.
Course of the day, we will file, Lordship. Rejoinder.
Ahmed GCH, Amma prays for the submits that matter, jointly file the course of the day.
Highly obliged, Lordship.
33.
Maybe.
My lord, this with regard to the VC, my lord. Last occasion, my colleague has conducted the hearing, my lord.
Who's your colleague?
Miss M. Rahman.
Where's MS M. Rahman?
She's unwell today, my lord. She's unwell, not well today. A vital infection, fever.
So what should we do?
My lord, next week, my lord, if she wants to argue this matter.
But you told her she's a hopeless case, correct?
Yes, my lord, she informed me. Only with regard to the verification of the job cards, my lord. My lord is well aware in the blocks, my lord, before conducting elections.
As MS M. Rahman said, to be unwell.
Yes, my lord. There is a mandate of the, my lord, before conducting election,
Yes.
verification has to conduct.
34.
Deeply obliged, ma'am.
My lord, I just received a copy of the affidavit filed by respondent number 4.
Yes, my lord.
So I'm just praying 2 days time, my lord, to seek instruction on the same.
Yes, Mr. Edakar submits he has just received the affidavit number 4. He prays for allowed 2 days time to seek instructions. Yes. When?
2 days. By Friday, my lord.
Friday is a holiday, Lordship.
Thursday, my lord.
Thursday not a good day. Yes, because TBD. Okay, we'll list on
Monday.
Monday.
Yes, ma'am.
Much obliged, my lord.
Thank you, ma'am.
36.
My lord, conducting counsel, Mr. SN is on his legs, my lord. I'm praying for an adjournment. I've informed the other side.
Yes.
Matter may kindly be adjourned, my lord, for today.
It's only a gate matter. We'll close it.
Lordships.
Who's appearing for what's that? Ito.
Ito, Lordships.
Yes.
Can be disposed of next week. It can come after a week, Lordship. When the seniors on next.
Why, Mr. Nogwar? Anything remains here? The terms over are still continuing.
No, it's still continuing.
He's
Still
going on. He's
December.
collecting now also.
No, there's an interim order passed by this court.
In his favor.
In fact, we had reduced the term of the
In his favors, he's continuing.
Lordships.
You're continuing or not?
I'm continuing.
Then it's okay after 1 week. Yes.
After 2 weeks also.
After 2 weeks, yes.
Much obliged.
Due to the absence of the iron counsel on behalf of the petitioner, this is a matter of 2 weeks.
Much obliged.
39.
May please your lordship. Lordship, this is a pension matter, my lord. But I think before proceeding, my lord, the notice has all been served to the private respondent, my lord, but she has failed to appear before this honorable court, my lord.
Your second wife?
Yes. I'm just praying the ex parte
What is her claim?
She's also claiming that she's the second wife, my lord.
Dispute between both the wives, both are claiming for the
Pension, my lord.
pensionary and retirement benefits, everything, your lordship. And there is a advice from the government that they should proceed.
You're the eldest surviving widow?
Yes. Because I've also enclosed the marriage certificate, my lord, in the petition.
You're not divorced, right?
No, not yet divorced, my lord.
Not yet divorced.
Not yet
Your
divorced, my
lordship,
lord.
because of this dispute, they cannot process his pension papers and everything.
Now from the...
Only thing is that, your lordship, this first wife has submitted legal notice, birth certificate of the children, marriage certificate. But the fifth respondent, respondent number 5, has not submitted only the death certificate. So...
Where's the petition before the respondents?
Before the respondents, my lord. Page 30, my lord. Oh, this is for the account general, my lord. Petition number.
This one, right? Account general, no?
This is 27, annexure 27. Page 27.
27 is the legal notice, my lord.
Legal notice. This is the only representation.
And we have sent reminders also, my lord.
Where's your...
Page 35, my lord.
This was to review.
Yes.
Now, where have they mentioned the case of the respondent in the rejecting your, not considering your pension? That's what we want to see.
This is the only representation.
Page 36, my lord. That's the impugn letter, my lord.
This 35 is not the impugned order. This is not impugned order.
No, double claimant.
Yes.
But are you sure she's been served?
Yeah, it has been served, my lord. We have also filed affidavit in service, my lord.
I think you do one thing.
Yes,
Which
sir.
police station is this? Rasubalpara.
Yes, my lord.
So we just one more time, because otherwise,
Yes, your lordship.
again, it'll come setting a
Yes,
party
sir.
order, Mr. E.G. Moon.
Because as per no nomination also there, it is enclosed by the petitioner herself, your
That's
lordship.
one, because we are talking about maybe she might have children who might be deprived.
No, she's not, doesn't have any children, my lord. That we are certain, my lord.
Anyway, take down loan affidavit indicating service upon the respondent number 5 has been filed since 6/10/2025. However, there has been no appearance till date. Stop. As the matter concerns pensionary benefits, which is contested by the petitioner respondent number 5, in the interest of justice, let notice be issued again to the respondent number 5. So, it is further directed that the respondent, that is,
Srimati Nirmanchi K. Marak. Srimati
no,
Nirmanchi.
respondent, you.
I am respondent
1 to 4.
1 to 3, your lordship.
1 to
4
3.
is AG.
Who's there on station there in that district?
Because affidavit filed by respondent number 2, your lordship.
Where is he based?
Based in Shillong. No.
Shillong, your lordship.
The director. Respondent number 2 is director.
Employment and Crafts Training, Meghalaya.
You do one thing. There's number 5 stop. The same on the copies being furnished by the petitioner. The registry shall forward the same to the it'll be the which police station is this? Officer in charge? Rasubalpara.
Rasubalpara.
Police station.
Yes.
Who shall then cause service upon the respondent number 5 at the given address.
Lordship.
Just up to 2 weeks. Just up to 2 weeks
Lordship.
for the orders. Just let her know.
Lordship.
41.
Highly blessed, my lord.
Much obliged, Your Lordship.
May it please your lordship, my lord.
Yes.
My lord, the only point here is, my lord, whether the government has, my lord, the power, my lord, to fix freight rates. My lord, after the amendment, my lord, of section 67 of the Motor Vehicles Act, my lord, on the 1st of September 2019, my lord, the power to, my lord, fix freight rates, my lord, has, my lord, been taken away. My lord, your lordship, my lord, in, my lord, when passing the interim order, my lord, on 17th December 2025, my lord, clearly noted, my lord, in paragraphs 4, 5 and 6, my lord, the provisions and, my lord, of course, prima facie came to the conclusion, my lord, that on the face of it, my lord, there is no power, my lord, for, my lord, fixation of, my lord, freight rates. Now, my lord, my respectful submission before your lordship is, my lord, if your lordship just takes the act, my lord, for 1 minute, my lord, I have also for your lordship's kind consideration, give the list of dates. Yes. My lord, prepared, my lord, a very short list of dates, my lord, which contains,
yes,
my lord, the provisions as well, my lord. So your lordship needn't have to look at the book all the time, my lord. My lord, kindly, my lord, prior to 1st September, my lord, 2019, my lord, kindly come straight away to, my lord, clause D. My lord, part to state government having regard to, my lord, clause D.
Oh, before you start here,
yes.
Mr. Sorry, I haven't got your name.
My lord, Mr. S.N. Mukherjee, my lord.
Yes, Mr. Mukherjee. There was initially there was a prayer for some
I'm told, my
made
lord.
on behalf of respondents. Who are those respondents? What was respondents?
They are the private respondents who are representing these unions. 8 to 13, Mr.
So are they, how vital are they to the issue?
Well, the state has to justify the action.
Respondent number 813, Lordship.
We can dispose this matter without hearing them. 8 to 13.
Yes. My lord, kindly hear them. My lord, I have one request, my lord.
We will hear you today.
Yes, my lord, kindly hear me today, my lord.
And from our part, we'll fix
my lord, we've come.
Date, Lordship. Yes. From our part, we'll fix another date.
Yes,
my lord, we've come through floods, my lord. Yesterday, my lord, was pretty bad.
We can understand, yes.
My lord, kindly, my lord, take, my lord, the first date, my lord, prior to 1st September 2019. My lord, section 67 I've set out. My lord, really, my lord, 1D, my lord, is what's important. State government having regard to, my lord, A, B, C, D, kindly see, desirability of preventing uneconomic competition among holders of permits may from time to time by notification in the official gazette issue directions both to the State Transport Authority and Regional Transport Authority, kindly note this, regarding the fixing of fares and freights, including the maximum and minimum in respect thereof for stage carriages, contract carriages and goods carriages. My lord, all these are defined, my lord, under the Act. Freight is not, fare is, and my lord, all, my lord, stage carriage, contract carriage, goods carriage. Goods carriage, my lord, does not relate to passengers, as the name suggests, my lord, it is, my lord, goods. Then, my lord, kindly come straight away to the second, my lord, in the list of dates, 1st September 2019. My lord, Motor Vehicles Amendment Act was brought into force, and my lord, your lordship will find section 67, power state government to control road transport, a state government having regard to. Now, my lord, kindly have a look at 4, promoting effective competition amongst the transport service providers may from time to time by notification in the official gazette issue directions both to the State Transport Authority and Regional Transport Authority regarding the passengers' convenience, economically competitive, kindly mark the word, my lord, fares, prevention of overcrowding and road safety. So, my lord, freight has gone out. My lord, from, my lord, and your lordships, my lord, I can't put it more succinctly, my lord, kindly take, my lord, your lordship's order, my lord, once, my lord, of 17th, my lord, December 2025.
Yes.
My lord, kindly have a look at paragraphs 4 to 6.
Yes.
Sir.
I'll just, my lord, kindly take, my lord, paragraph 4 once.
Yes.
As such. My lord, Yes. My Lord, kindly see para 4. As such, on a consideration of the interim prayers, this court, on examining the amended provision, that is section 67(1), notes that 67(1)(d), which is reproduced herein below, speaks only about fares.
Yes.
And a perusal of the unamended section 67 shows that prior to so-and-so, the same read as follows. 6. As such, a bare perusal of the above quoted provision shows that the state respondents on the provision being amended are no longer vested with the power to fix freight rates. Accordingly, the operation of the impugned notification shall therefore be kept in abeyance during the pendency of the instant writ petition. My Lord, this was, I'll take it as a prima facie view, but my Lord, on the face of it, my Lord, this is, my Lord, the position. Now, my Lord, two very important things follow. My Lord, if this is, my Lord, I'm right in my submission. My Lord, the first is, my Lord, this, if your Lordship looks at the preamble to this act, my Lord, this is a consolidating and amending statute.
Yes.
Now, my Lord, it is, my Lord, if your Lordship sees, my Lord, an act to consolidate and amend the law relating to, I'm sorry, my Lord, 1980. My Lord, if it's the same book, my Lord, it will be page 18. Oh, different book.
Yes.
My Lord, kindly see an act to consolidate and amend the law relating to motor vehicles.
Yes.
In other words, my Lord, it's a complete code. So, my Lord, if it's, and my Lord, the Supreme Court, my Lord, has recognized, my Lord, this to be, my Lord, a complete code. My Lord, I'll give your Lordship, my Lord, the reference. I have a copy, my Lord.
No, that's a given, yes.
Yes.
Please continue.
Yes, 2008, 3 SCC 464, para 11. Now, my Lord, if it's a complete code, then, my Lord, state is barred, my Lord, from fixing the freight rate. My Lord, this has been, my Lord, decided, my Lord, in Force Ray Lawson's case. That was, my Lord, under the Arbitration Act. My Lord, the power, the right to appeal. My Lord, they said if it's a complete code, all letters patent appeal, etc., all, my Lord, taken away. Because, my Lord, appeal also, my Lord, is a creature of statute. And, my Lord, it says, my Lord, therefore the state is barred from, my Lord, fixing the freight rate. Now, my Lord, factually, I don't know, my Lord, in law it won't carry weight because the interpretation is, my Lord, before your Lordship. My Lord, there's a meeting, my Lord, here where the Advocate General of the state, my Lord, on 27 November 2025, that's, my Lord, petition annexure 27, page 199. My Lord, had also opined, my Lord, 199, last two lines, my Lord. This is the minutes of the meeting where all were present, 27 November 2025. After, your Lordship has that, my Lord, right at the bottom. Last, Advocate General informed that after the amendment of the so-and-so in 2000, the state government is no more authorized to fix freight rates. This is the view. Now, my Lord, I must tell your Lordship, my Lord, that is the view of 8 to 13 also. They have affirmed an affidavit. My Lord, your Lordship will kindly take that, my Lord, affidavit once. My Lord, that is, my Lord, the respondent numbers 8 to 13. Yeah, the truckers, my Lord.
Yes.
My Lord, kindly have a look at the last 3 lines of page 3, my Lord.
Yes.
The 2019 amendment does not dismantle state power, it reconfigures it, shifting from ad hoc price fixation under section 67(1) to a robust scheme-based protective framework under 67(3), 88A and 93. The state's interventions therefore are not executive overreach but lawful fulfillment of its duties as parents portray to prevent the economic annihilation of vulnerable local industry. So, my Lord, fixing of, my Lord, price regime, my Lord, freight rates, my Lord, has, my Lord, gone out. That is their case also. Now, my Lord, may I deal with the contentions, my Lord, of the respondents. My Lord, some of them are common, some of them are only by the state, and some of them are, my Lord, by the unions, my Lord, my Lord, transport providers. My Lord, the first is, my Lord, 67(2) and 84C still remain on the statute book. And, my Lord, there is submission before your Lordship is my lord, if your lordship looks at, my lord, 67(2) and 84(c), that, my lord, fixation of, reference to fixation of freight rates, my lord, has, my lord, not, my lord, been, my lord, amended in these sections. My lord, kindly take 67(2).
Yes.
My lord, any direction under subsection 1 regarding the fixing of fares and freights for stage carriages, I'm sorry, my lord, 67(2).
Yes.
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 Now, my lord, 2, my lord, was not amended when 1 was amended. 2 remained. Any direction under subsection 1 regarding the fixing of fares and freights for stage carriages, contract carriages, and goods carriages may provide that such fares or freights shall be inclusive of the tax payable by the passengers or the consignors of the goods, as the case may be, to the operators of the stage carriages, contract carriages, or goods carriages under any law for the time being in force relating to tax on passengers and goods. Then, my lord, proviso has really, my lord, is not, my lord, relevant. Kindly come to 84, section 84(c), my lord.
Yes.
Kindly see, my lord, the following shall be conditions of every permit. Kindly come to C, that any prohibition or restriction imposed and any fares or freight fixed by notification made under section 67 are observed in connection with the vehicle to which the permit relates. So, my lord, the respectful submission, my lord, which, my lord, the respondents have made, my lord, is, my lord, to the effect that, my lord,
yes,
matters pertaining to fixation of freight, my lord, have not been totally eliminated. So there is, my lord, a right, my lord, and a power to, my lord, fix, my lord, freight. Now, my lord, I make, my lord, 3 submissions apropos this. My lord, these are incidental provisions which do not give the power, my lord, to fix freight rates. Then, my lord, the amendment here was intended, my lord, the legislative intent was to bring about, my lord, a change in law. My lord, parties and courts cannot proceed on the basis, my lord, when the amendment to 167(1) has been introduced.
Can be diluted by another.
Correct. And, my lord, that old law was to continue. There was a purpose for, my lord, amendment. And, my lord, legislative intent cannot be defeated by this omission. My lord, I have, my lord, 2 cases on this, if your lordship permits. My lord, I'll cite it, but otherwise I can give your lordship, my lord.
What does it say?
My lord, first is, my lord, 1961 SCC online.
Supreme Court.
Yes, my lord. I will, my lord, only cite Supreme Court before your lordship, my lord. My lord, if I hadn't found Supreme Court, my lord, I might have cited High Courts. My lord, kindly take, my lord, 1961.
Yes.
My lord, this again related to, my lord, arbitration. Your lordship's aware, my lord, of the Mahindra supply case. My lord, where, my lord, under the old Arbitration Act 1940, my lord, the question arose, my lord, whether, my lord, under section 39, my lord, a letters patent appeal would lie. Kindly come to para 7, my lord, about, my lord, 8 lines, my lord, after the start of the paragraph, sentence starting, my lord, in considering. Lordships, kindly take, my lord, in considering the argument.
Yes, they're quoting another judgment.
Yes.
Yes.
My lord, kindly, my lord, see, my lord, in considering the argument whether the right of appeal which was previously exercisable by litigants against decisions of single judges of the High Courts in appeals from orders passed in arbitration proceedings was intended to be taken away by 39(2) of the Indian Arbitration Act. The court, now kindly see this, must proceed to interpret the words of the statute without any predisposition towards the state of the law before the Arbitration Act was enacted. The Arbitration Act of 40 is a consolidated and amending statute and is for all purposes a code relating to arbitration. In dealing with the interpretation of the Indian Succession Act, the Privy Council in Narendranath Sarkar and Kamalvachani Desai observed that a code must be construed according to the natural meaning of the language used and not on the presumption that it was intended to leave the existing law unaltered. So, my lord, if there is an amendment, there is an intention, my lord, to, my lord. Now, my lord, kindly come to, my lord, I am not troubling your lordship with the quotation, my lord. The last 3 lines of that are, my lord, important, but, my lord, it's summarized in the last 3 lines on that page. The court, in interpreting a statute, must therefore proceed without seeking to add words which are not found in the statute, nor is it permissible in interpreting a statute which codifies a branch of the law to start with the assumption that it was not intended to alter the pre-existing law, nor to add words which are not found in the statute, etc. Now, my lord, this, my lord, legislative intent, my lord, as reflected in the amendment to section 67(1), my lord, cannot be, my lord, defeated by the omission to, my lord, make suitable amendments to the incidental provisions, which is 67(2) and, my lord, 84C. My lord, kindly take, my lord, 2016, 3 Supreme Court cases, 788. My lord, just 2 paragraphs I wish to place, my lord. Paragraph 39. My lord,
yes,
a very interesting argument, my lord, was made. My lord, under section 46A, my lord, of the Banking Regulation Act, my lord, office bearers and employees of banking companies were, my lord, treated as public servants for the purposes of Chapter 9 of, my lord, the Indian Penal Code. Now, my lord, what happened was, we, my lord, had the Prevention of Corruption Act, and, my lord, the offences prescribed, my lord, in Chapter 9, my lord, of the Penal Code came to be deleted, and they were engrafted in Section 7 to 12 of the Act. My lord, in this provision, my lord, your lordship's aware, Prevention of Corruption Act, my lord, had, my lord, a very wide definition, my lord, of a public servant. What was argued was, sorry, Banking Regulation Act has not been amended. So even though Prevention of Corruption Act is wide enough, you cannot treat the officers as public servants. Now, my lord, kindly have a look at 39. Your lordship's seen that, I believe, my lord, already. Kindly come straight away to 45, my lord.
yes.
Turning to the case in hand, there can be no dispute that before the enactment of the PC Act, Section 46A of the BR Act, Banking Regulation, had the effect of treating employees, office bearers concerned of a banking company as public servants for the purpose of Chapter 9 IPC by virtue of the deeming provision contained therein. The enactment of the PC Act with the clear intent to widen the definition of public servant cannot be allowed to have the opposite effect by expressing judicial helplessness to rectify or fill up what is a clear omission in 46A of BR Act. The omission to continue to extend the deeming provisions of 46A of BR Act to the offences under Section 7 to 12 of PC Act must be understood to be clearly unintended and hence capable of admitting a judicial exercise to fill up the same. The unequivocal legislative intent to widen the definition of public servant by enacting the PC Act cannot be allowed to be defeated by interpreting and understanding the omission in 46A.
This is in 2 acts.
Correct. Here it's in 1. Correct. My lord, I say, my lord, the same, my lord, principles, my lord, will, my lord, apply. Now, my lord, kindly take, my lord, the next, my lord, contention, my lord, of the respondents. Now, my lord, I must point out, this is a contention only by the private respondents, not by the state. First one, my lord, is, my lord, common. My lord, this is, my lord, Section 67(3) and Section 88A, capital A, my lord, of the Motor Vehicles Act have been relied on. Now, my lord, the argument is that, my lord, under Section 67(3), your lordship, my lord, kindly comes to Section 67(3).
Notwithstanding.
Yes, notwithstanding anything contained in this Act, the state government may by notification in the official gazette modify and any permit issued under this Act or make schemes for the transportation of goods and passengers and issue licenses under such scheme for the promotion of development and efficiency in transportation. And, my lord, several clauses are given. My lord, the reliance is, my lord, on clause G. The enhancement of economic vitality of the area through competitiveness, productivity and efficiency. My lord, they construe this clause to, my lord, permit, my lord, fixation of freight rates. But my lord,
to promote the
my lord, but my lord, yes, but it's of the area. It is not, my lord, of, my lord, the transport service providers.
So what do you mean by true competitiveness?
My lord, competitiveness, productive.
You mean competitive rates or competitive?
My lord, it's a free market. So, my lord,
Exactly,
correct. So, my lord, the rates cannot be fixed.
So competitive rates.
Correct. My lord, it's a free market. My lord, the rates market forces will determine it.
Okay.
My lord, now, my lord, what is important is, my lord, admitted fact is, my lord, the scheme, my lord, no scheme has been framed. In fact, a prayer, my lord, before your lordship says, please direct the state government to frame a scheme.
Yes.
That's the prayer there is, because the state has not taken, my lord, this point. And, my lord, 88A, your lordship will notice, my lord, is framing of scheme by the central government, not, my lord, state government at all. Now, my lord, kindly.
Ground taken by the state.
No, it's not a ground. Now, my lord, kindly, my lord, take, my lord, just, my lord, one, my lord, affidavit, my lord, of respondent numbers 8 to 13, my lord, at pages 10 and 11 and page 18.
10 to 13.
Yes, my lord, this is 8 to 13, my lord. 8 to 13. Page 10 and 11. Kindly have a look, my lord. My lord, the heading is Roman 3, statutory mandate for protective schemes under 67(3) and 93 of Motor Vehicles Act.
Yes.
Now, my lord, 67 empowers the state government to frame schemes for transportation under which transport licenses, subclauses G and L of say specifically enhance economic and promote integration of transportation system. Administrative minutes requiring a daily deployment of 80 to 120, which the petitioners characterize as coercive, represent in truth the embryonic form of precisely such a statutory scheme. The answering respondents call upon this honorable court to direct the state government to formalize these arrangements into a full-fledged cement logistics scheme under 67(3), which would prescribe minimum freight rate, guarantee reservation, establish transport. So, my lord, the scheme, my lord, is not there. And, my lord, there's one other, my lord, paragraph. Your lordship will kindly see, my lord, at page 18. My lord, third line, my lord, at page 18, just above paragraph 6. The answering I'm sorry, my lord.
Yes.
The answering respondents therefore demand that this honorable court, in the exercise of its powers under Article 226, direct that any logistical scheme framed under 67(3) expressly address and regulate the extent to it.
Yes.
Now, my lord, I first say, even, my lord, scheme doesn't give the power, but this is, my lord, no need to go into this here, because admittedly, my lord,
there's no scheme. Yes.
There's no scheme. Not only that, my lord, all the notifications, my lord, which have been issued, say they have been issued under 67(1). And third, my lord, when they justify the notifications, they rely on the unamended provision.
Yes.
That will appear, my lord, from the list of dates. Then, my lord, another, my lord, point which has been taken, my lord, this is again not the defense of the state. My lord, this is, my lord, only, my lord, the private respondents. They say, in reality, the petitioner is an aggregator. Being an aggregator, it is required to give us welfare benefits. Since it is not giving us welfare benefits, it cannot complain against the fixation of freight rates. My lord, with the greatest of respect, my lord, 93, my lord, read with, my lord, section, my lord, 2(1) capital A of the Act. My lord, an aggregator, my lord, is one who provides a digital marketplace. Like, my lord, for Uber. My lord, as far as, my lord, Uber and Ola, my lord, as far as, my lord, vehicles are concerned. If your lordships take, my lord, 2(1)(a), my lord, of the Act.
2(1)(a).
1(a), my lord. My lord, kindly have a look, my lord.
Aggregator.
Kindly note, means a digital intermediary or a marketplace. Now, my lord, for what? For a passenger to connect with the driver for the purpose of transportation. So first a digital platform or marketplace, and, my lord, for whose benefit? For a passenger to connect with a driver. My lord, here, my lord, there is no passenger involved. My lord, it's transportation of goods. And now, my lord, am I a digital platform? Now, my lord, kindly, my lord, take, my lord, the next, my lord, point. Now, this has been taken by the state. They, my lord, say, my lord, under entry 35 of the concurrent list, my lord, the state, my lord, and the union, my lord, both have, my lord, coextensive executive and legislative powers.
Yes.
Now, my lord, therefore, my lord, they can issue a notification. Now, my lord, with the greatest of respect, my lord, Article 254 of the Constitution, my lord, once, my lord, there is a central legislation, yes, it will override unless, my lord, the assent, my lord, of the president is taken by the state for a, my lord, subsequent. My lord, I am not troubling your lordship, my lord, with cases on that. Then, my lord, what has been, my lord, contended by the state, this is only by the state, with a faint hint, my lord, from, my lord, the, my lord, transport operators, my lord, that's, my lord, entry 1 and 2 of list 2, my lord, law and order. My lord, they say, for law and order, my lord, they had to do this. Now, my lord, with the greatest of respect again, my lord, to enforce law and order is to ensure, my lord, that the law is observed. My lord, not, my lord, to, my lord, do something which is, my lord, contrary to law and say I had to do it to maintain law and order. So, my lord, even this, my lord, with the greatest of respect, cannot, my lord, be, my lord, maintained. Then, my lord, another argument has been advanced. My lord, I have almost finished, my lord, just 2 points. My lord, that, my lord, the definition of fare, kindly have a look at the definition, my lord, of fare, my lord, section 2, subsection 12 of the Motor Vehicles Act. In fact, my lord, while on the law and order, my lord, really, my lord, if, my lord, your lordship upholds my contentions, my lord, it's an obligation to see, my lord, that it's carried out. They can't say, oh, law and order, I won't take steps to deal with a strike. I won't let people negotiate and enter into an arrangement. They have to, my lord, provide, my lord, all, my lord, assistance there. Now, my lord, the next is, my lord, fare. Kindly see the definition, my lord, of fare in, my lord, 212. My lord, fares include sums payable for a season ticket or in respect of the hire of a contract carriage. Now, my lord, kindly have a look at contract carriage. My lord, 2.7. Contract carriage means a motor vehicle which carries a passenger or passengers for hire or reward. So, my lord, again, my lord, it deals with, my lord, passengers. They said, no, it's inclusive. So, it's been widened to include this. Now, my lord, what does it include? A season ticket rather than a daily ticket, and a hire of a contract of carriage rather than, my lord, a cab fare for, my lord, a particular journey. I'm hiring the car for, my lord, transportation from A to B, my lord, it will cover that. Now, my lord, in the normal meaning also, my lord, the natural meaning of, my lord, fare, and, my lord, if that was to apply, and then, my lord, we read, my lord, the inclusive definition here, my lord, it has been consistently, my lord, I wouldn't say held, my lord, the dictionaries, my lord, say, my lord, that fare is related to, my lord, consideration for passengers, and, my lord, freight, my lord, relates to transportation of goods. My lord, I'm not
a general, I mean,
yes,
balance, commercial.
Yes, commercial, and, my lord, it's there in 2 dictionaries. My lord, I'll just cite the, my lord, I'm not troubling you, I'm just giving, my lord, and I'll give my learned friends, my lord, the relevant extracts, my lord, which I have. Now, my lord, an argument has been made that, well,
yes,
your representatives were present at the meetings where we took the decision, where a decision was taken to fix the freight. So you are a party to that decision, you cannot challenge it. Now, my lords, I have a simple answer to it, my lord. There cannot be, my lord, estoppel, my lord, against, my lord, law or, my lord, statute. I don't want to give. And my lord,
You have taken the ground also.
my lord,
That is present
not
in
the, my lord, no, my lord, all of them have, my lord, that you were present in the decision making. Now, my lord, one other thing I must indicate, my lord, when your lordships pass the interim order,
Yes.
my lord, in paragraph, my lord, 7, if I'm not mistaken, your lordship, my lord, had apprehended, my lord, cartelization on the part of, my lord, the manufacturers, the cement manufacturers, and your lordships, my lord, had, my lord, after, my lord, hearing us, my lord, did, my lord, by media, my lord, with regard to the rate. That was for interim. Now, my lord, we filed an application to say, my lord, why, my lord, we do not indulge in cartelization. We have given, my lord, the process, my lord, which we follow, my lord, for, my lord, fixing the, my lord, for, my lord, availing of services of, my lord, transport providers. My lord, we are, my lord, as, my lord, Mr. Paul put it to your lordship on the last occasion, my lord, we do it individually for the purposes of, my lord, carriage of goods. Though we are before your lordships, my lord, as a group, my lord, challenging, my lord, these notifications for fixing of freight rate. And we have stated that, my lord, in, my lord, paragraphs, my lord, 7 and 8, page 14 of, my lord, our application. As to how, my lord, we have, my lord, avail of, my lord, services provided, my lord, by transporters. My lord, we either have spot fixing, or, my lord, we have, my lord, competitive tender-based bidding, or, my lord, we have, my lord, vehicle-wise, my lord, contracts, my lord, which are, my lord, entered into. And we've said that, and that is not in dispute at all.
Yes.
So, my lord, really, my lord, and we've explained, cartelization will not really help, my lord, the, my lord, individual manufacturer. Yes.
Yes.
My lord, we have amongst us also, my lord, people who are, my lord, far more solvent than, my lord, the other person. So, my lord, cartelization will not, my lord, help at all. And in any event, my lord, as your lordship's aware, all this, my lord, has now gone into the field of Competition Act, where, my lord, all, my lord, provisions are made. Earlier, my lord, your lordship was aware, my lord, law frowned upon monopolies, did not encourage it at all. Now, my lord, monopolies are not frowned upon, but, my lord, what is frowned upon is, my lord, an abuse of a dominant position. So, my lord, if there is a abuse by predatory pricing, etc., my lord, an investigation, my lord, can be, my lord, started, my lord, in, my lord, before the competition, my lord, authorities.
Yes.
My lord, anything else? My lord, those are my submissions. My lord, I'm very grateful, my lord, for accommodating me today, and in the past as well, my lord. Couple of times I tried through, my lord, video conferencing, my lord. First day it worked, my lord. I was hurtful, but the second time round, my lord, I realized, my lord, I was not being, my lord,
Thank you.
able to get through.
Brian, some other day, your lordship.
You fix the date, but not too far away.
No, your lordship. Next week only, your lordship.
Yes, after
Next
1 week.
only, your lordship. Yes.
For replies, yes.
Certainly, I'll not take time on the next date, your lordship.
It's very limited.
Very limited, your lordship.
Much to argue also.
And as I was telling Mr. Paul, my lord, my childhood, my lord, was spent substantially in Shillong.
Oh, that's wonderful.
Yes. So, my lord, my grandparents, my lord, lived here from 1920s. Okay. And, my lord, I used to visit them, my lord, as a little child, because Durga Puja was held at our home here. For 2 months from Calcutta, we'd come here.
Which part of Shillong was this?
My lord, this was on Bishop Cotton Road, a house called Stonycroft.
Okay. Yes.
So, my lord.
Opposite
Wonderful.
the CRPF camp.
Right.
Click that photo.
That's now Mr. Agarwal of my
Correct. In fact, my lord, last time I was here on holiday, my lord, the then Chief Justice of the High Court, my lord, Justice Sanjeev Banerjee, who used to be in the same chambers as me, called up, my lord, the persons who now occupy the house so that I could take my wife, my lord, to see, my lord.
Is there a bonded warehouse there now?
Yes.
I don't think that's what your grandparents invested.
No, never. They didn't. My lord, we could see the river, we could see the polo grounds, we could see the race course, and we could see the golf course on a clear day.
Now it's not possible.
Not possible at all.
Thank you. Yes.
Oh, bless you.
Your Lordship, I pray for
next week.
Yes.
I pray for 2 weeks time.
You're appearing for?
Respondent number 8 to 13.
No, she's appearing for whom?
For the agent.
We're having after a week for replies. Yes.
Lordship, after a week only, Your Lordship.
Yes.
Your Lordship, because senior, he is in serious condition.
He is very unwell.
Yes, Your Lordship.
Oh.
Sir Erwin.
Then we'll take up to 10 days. Let's take a chance.
2 weeks,
We'll
yes.
try to complete it. Yes.
Much obliged.
Apply, Your Lordship.
With your Lordship's kind permission, may I mention
Yes.
item 8 and 9 on your Lordship's board today? I apologize, I could not join in the first round.
8 and 9, 8 and 9
Requesting
part
that
1.
Yes, your Lordship.
No more mentioning, sorry.
Daily call.
Sorry.
My presence may be recorded, your Lordship.
Yes.
43.
This is a case, Lordship. Here I am asking for the interest for the delay payment of release of the retirement benefits. On 2nd June 2026, Lordship, I was asked to on 2nd June 2026.
To bring the
Instruction as the exact amount withdrawn by the petitioner, Lordship. This is the statement.
You have a copy of that?
Statement,
given by you.
Give me it.
So this is a bank statement, Lordship.
Exact amount drawn by, I don't remember.
My Lord, there is an order, Lordship, 2nd of June.
2nd of June?
June. Matter was heard at length.
Yes.
My Lord will see the page number 2, Lordship.
Page number 2.
2.
5,22,000.
Yes, Lordship. Then this would be the leave salary. Lordship, page number 3.
22,66,000.
Yeah, 22,06,000 and
5 lakhs.
5 lakhs.
What amounts are these?
This will be the, my Lord, this is the area.
Yes.
That pension, that 22 lakhs. And 5,67,000 is the area ACP, Lordship, because that ACP was not calculated. Now, Lordship will see the page number 5.
Of your petition?
Yeah, no, my Lord, in the same. Yes, Lordship.
8,61,000.
Yes. As per the instruction, this is the gratuity amount, Lordship. Then all together, Lordship, 43,17,432, Lordship.
You have drawn?
Withdrawn, Lordship.
Well, now what remains here?
No, my Lord, here.
Your interest is 8 lakhs.
No, my Lord, on retirement benefits, Lordship. All the retirement
on the entire amount?
Yes, Lordship.
How much? From when? When is it delayed? How long?
He retired on 2017, Lordship. Now in
and pension it was released from.
What was the hold up? What was the hold up?
2024.
No, why was it?
Lordship, due to procedural and administrative lapses, Lordship.
Or she or he?
No, she was a regular
appointee.
After retirement, he met with an accident, he died. Then due to administrative lapses, and that has been admitted by the government because of some
administrative lapses. Non-submission of F3, F4 form, correction of name, and then the pay had to be regularized.
Attributable only to the respondents or
only to the respondent, Lordship.
Also
now, after I filed the case, then only they have released all the
themselves.
Yes, Lordship. Now, on the earlier date also, my Lord, I have relied one paragraph saying that they have admitted that this is a administrative lapses.
Where is that admission?
My Lord, paragraph 11.
Of the affidavit?
My affidavit filed by the State Lordship. That is why my Lord have paragraph 11, first sentence, Lordship, page 4.
Yes.
That with regard to the abatement made in para 8, 9 and 10 of the writ petition, the answering response submits that the delay in the processing and payment of family and service benefit was not intended but due to certain procedural and administrative lapses.
Yes, I remember this matter now.
Administrative lapses.
It was received in 20 and then?
They have given some.
23. Now now this is PHE?
Yes, Lordship.
Department. So who is the person who was responsible for the delay?
Even his pay also, Lordship, had to be regularized, Lordship, from the year 1993. And successive orders for grant of extended pay, ACPS, MACPS and fresh approvals also had to be issued fresh approvals
But
issued.
that had been done during the duration of his service.
Yes, that law is very clear within 2 years.
So who will build the cat? Who will pay this?
So Lordship, here
My lord,
he
here
retired from.
settling responsibility. So one of the respondent, because here the
See, what is
lapses.
normally done in such cases, Mr. Sheikh?
My lord, government lordship.
No, why should the government bear? The thing is that the government can pay, correct, for the interest. But the person who is guilty of the laches in not processing the papers and depriving some, employee of due benefits, that is deducted from their salary.
My lord, there is some judgment directly that the liability was saddled to the government. Court
Liability
has
comes
given,
from the government, yes. That means
Court has given direction.
government will immediately release that interest amount to you. But it's further for the government to recover it from the salary of those people, or pension from those people who are responsible for the delay.
My lord, what I suggest, lordship, my lord can decide that matter, lordship. Now the liberty can be given to the government to recover from the officer concerned who is responsible for such administrative delays. And there are catena of judgment, lordship, with regard to that. Even pension also says that they have to pay the
Yes, so how much interest are you looking
Lordship, here this regularization of pay and all, Lordship, it involved more than one department, establishment, Lordship. So,
No, but one thing is that, see, Mr. Kharmi, what stares us in the face is that he retired in 2017.
2017.
Right? And pension papers were forwarded from Ampati division in 23. That is after a period of 6 years after he retired.
Yes.
So that means this poor person, after he retired, did not get any of the any benefits for 6 years. How will he survive?
Yes.
Of course, he's dead now, poor fellow, whatever. And then someone has to someone has to be responsible. Now he's dead, don't get benefits, but his wife and family have received 80, how much? 45 lakhs.
42 lakhs, lordship.
All told.
All total. This is
total means with leave encashment, and MACP, and gratuity,
and the arrear pension.
And arrear pension comes to 88, 45
42. Arrear pension is 22 lakhs, 66,000.
Lordship, let him supply me the statement, then I'll obtain the instruction.
No, this is my bank statement. I can give no.
Because from the affidavit also, Lordship, it is.
No, the amount is not the only thing the court want to know. What is the amount that you've got actually?
My lord, this is the bank.
We'll fix the notional amount.
Yes, this is the bank.
Paid 10 lakhs.
This is the bank statement. Now my friend
Lordship,
also
can
can
the instruction.
verify. Yes, lordship.
Because it is not involved only one establishment.
Has produced an account statement of the petitioner, which shows that she has received from 24/9/2024 onwards, amount totaling to
42 lakhs 17,000 something, lordship.
Approximately 42 lakhs.
Yes.
It is further submitted that the delay in the release of the terminal benefits of the petitioner being attributable to the respondents, which has also been admitted in affidavit, an interest amount may perhaps be affixed to compensate for the same stuff. Mr. H. Kharmi, Nekara learned senior advocate on the submission, prays and without to obtain some instructions. Otherwise, we'll fix your notional amount or some interest and recover it from those officers concerned. How we cover it is not a headache. Yes.
I'll just get instruction on this and can dispose next year.
Hello.
Can copy yours.
Second call, item number 29.
Okay.
This for appointment of arbitrator, my lord.
No, this is for the delay.
Yes, my lord. There's application for appointment of arbitrator. We have taken a plea that the application is time barred now. Now,
because they can take the ground before the.
No, I'll place. It is very clear now, my lord. Even after the 7-judge decision, I'll just place 3 decisions, my lord.
Yes.
Post interplay, my lord.
Arif Azim.
Yes, my lord, first thing I'll just point out, my lord, that interplay judgment is delivered on.
Did you give a copy of the judgment last time, Mr. Chanda?
Lordship, we have given a compilation, Lordship.
Where's the compilation?
It was already submitted, Lordship.
This is your thick compilation?
Lordship.
Yes, Lordship. They refer to only two decisions, my lord, out of this compilation.
Interplay between arbitration agreement so and Uttarakhand
Yes.
Sainik
Yes,
Kalyan Nigam.
Now, my lord, in this compilation, your lordship kindly sees page 155.
Arif Azim has been dealt with.
Sorry.
What my friend is referring to, my lord, is Arif Azim. Arif Azim has been dealt with in there.
There are some.
No, let him please.
Yes.
Yes, yes. Where? Which page of this?
Page 130, my lord.
One?
130. Mr. Paul's compilation. I was just trying to point out, my lord.
130 is last page.
Yes, my lord. So I just pointing out the quorum, my lord.
Judge Constitution bench. Yes.
My lord. And the Justice Chandrachud, my lord. Justice Pardiwala and Justice Manoj Mishra were a part of the bench, my lord. And this
Manoj
is
Mishra, Pardiwala.
and Justice Manoj Mishra.
Yes.
Judgment delivered on 13 December 23, my lord.
Yes.
Now, my lordship kindly sees my compilation now, my lord.
You said it on 24.
Yes, these are all post interplay judgments.
Just within 17 days. Oh no, it's March.
It's after 4 months, right? So bench lordship will see Justice Chandrachud, Pardiwala and Manoj Mishra.
Yes.
Now, if by this judgment, I'll take lordship to para 46, 51.
1 second.
Well,
46.
I'll point out to para 46, 51, 53, 57, 65, 66 and 75.
57.
65, 66 and
65,
75.
66 and 75.
This one.
Yes.
The para 46 one.
They came after how long?
10, 15 days.
How many years?
We are saying, my lords, it's a continuing cause of action
So how
because
many
we
years?
filed the affidavit now before your lordships.
How many years?
No.
You're filing the affidavit now?
No. In the affidavit that they have filed now, my lords, it has come to your lordships that
No, let him please.
No, I'll just responding to the query of this honorable court, my lords. The final bill in respect of this very work, my lords, was settled on 2/5/2023.
But 23 was the last one. Yes, 23.
Lordships.
Okay.
So 23, 26, my lords, otherwise also 3 years limitation would be covered. That's the second limb of my argument.
Okay, just come to 46 then.
My lord, since your lordship put the query, my lord, I'll just place their rejoinder, my lord. Your lordship has for a moment. Is the rejoinder filed on 16/9/25 by the petitioner.
Yes.
Kindly see annexure 1, page 5 of this rejoinder. Your lordship, kindly come to page 6.
Yes.
Page 6, my lord. Is there document, my lord?
Yes.
My lordship, you can see 27th February 2006, date of commencement. Third item, my lord.
Yes. Yes, final bill received. But
No, my lord, I'll just point out 4 dates, my lord, what is relevant. 27 February, completion date was originally 26 August 2007, my lord.
Yes.
The lordship, kindly see next page, my lord, 30th July 2010, when they actually completed the work. 30th July.
Yes, actual completion. Yes.
Actual date of completion, my lord. Kindly see 12 November 2020
Yes, claim submitted.
by us with request to appoint arbitrator to adjudicate upon the disputed part, my lord.
Claim submitted by us, being by them.
By the petitioner, my lord. And next date, my lord, 19 December 2020. This is when they requested the appointing authority for appointment of arbitrator.
Yes.
So, my lord, I'll just 3 dates are relevant for my submissions, my lord. Date of completion of work 30th July 2010, my lord. Appointment request Section 21 application from them comes on 19 December 2020, my lord. And one more relevant date, my lord. This Section 11 application is filed on 23 May 2025, my lord.
So you're saying after actually the completion, 3 years count goes from there?
My lord, they are belated on both counts, my lord. Their claim is time barred, my lord. Secondly, from Section 21 application,
yes,
which is dated 19th December 2020, my lord, their Section 11 application itself is also time barred, my lord.
yes.
Request for appointing arbitrator 19th December 2020, my lord. Section 11 application filed on this date, your lordship will see at the petition, my lord, 23 May 2025, my lord.
Okay.
Now I'll just refer to para 46, my lord, of the judgment. Plain reading of Section 11(6) of the 1996 Act, which provides for the appointment of arbitrator, indicates that no time limit has been prescribed for filing an application under the said section. However, Section 43 of the 96 Act provides that the limitation act shall apply. Now, my lord, para 51.
Yes.
Having traversed the statutory framework and the case law, we are of clear view that there is no doubt as to the applicability of the Limitation Act 1963 to arbitration proceedings in general, and that of Article 137 of the Limitation Act to a petition under 11(6) of the 96 Act in particular. Having held thus, the next question that falls for our consideration whether the present petition seeking appointment of arbitrator is barred by limitation. Para 53, my lord.
Yes.
It has been held in a catena of decisions of this court that the limitation period for making an application seeking appointment of arbitrator must not be conflated or confused with the limitation period for raising the substantive claim which are sought to be referred to the arbitral proceedings. Well, that's why I am pointing out cause of action to Section 21 application, my lord. The limitation period for filing an application seeking appointment of arbitrator commences only after the valid notice invoking arbitration has been issued by one of the parties to the other.
Yes.
And there has been either a failure or refusal on the part of the other party to make an appointment. So this date, my lord, in our case is 19th of December 2020, my lord.
Yes.
Now, my lord, para 57, my lord, the last sentence of this para, my lord. Last para.
Thus the limitation.
Thus, the limitation period for filing a petition under Section 11(6) of the Act can only commence once a valid notice invoking arbitration has been sent by the applicant to the other party and there has been a failure or refusal on the other party in complying with the requirements, my lord. Number 65 and 66. There are two categories of issues that may be raised against an application for appointment of arbitrator under 11(6) of the Act. The first category is of the issue pertaining to the power and authority of the arbitrator to hear and decide a case, and are referred to as the jurisdictional issues, objections. Objections to the competence of arbitrator to adjudicate a dispute, existence, validity of arbitration agreement, absence of consent of the parties to submit their dispute to arbitration, dispute falling outside the scope of the arbitration agreement are some examples of jurisdictional or maintainability issue. The second category is those issues which are related to the nature of the claim and include challenges to procedural requirements and mandatory requirement for reference mediation, claim or party thereof being barred by limitation at the category is referred to as the administrative issue. Now, my lord, so what the Supreme Court distinguished, my lord, is one is with regard to limitation on substantive claim, my lord. Second is on approaching under 11(6), my lord. Now, B, my lord, flag B.
Yes.
This is again by the Justice Chandrachud, Justice Pardiwala, and Justice Madhav Mishra, my lord. Post interplay, my lord. But this is a long judgment because I only extracted the relevant part, my lord. Para 129 onwards, I'll just read.
Yes.
Para 129. Before we close the matter, it is necessary for us to clarify the dictum as laid in Arif Azim versus Aptec, so as to streamline the position of law and prevent the possibility of any conflict between the two decisions that may arise in future. In Arif Azimji, while deciding an application for appointment of arbitrator under 11(6) of the 92 issues had been had a reason for our consideration. Whether the Limitation Act is applicable to an application for appointment of arbitrator under 11(6) of the Act. If yes, whether the petition filed by Arif Azimji was barred by limitation. Whether the court may decline to make a reference under section 11 of the Act where the claims are ex facie and hopelessly time barred. On the first issue, it was observed by us that the Limitation Act is applicable to the application under 11(6). Further, we also noted that it is the duty of the referral court to examine that the application under 11(6) of the 96 Act is not barred by period of limitation as prescribed under 137 of the Limitation Act. That is 3 years from the date when the right to apply accrues in favor of the applicant. To determine as to when the right to apply accrued, we had observed in para 57 of the said decision that the limitation period for filing a petition under section 11 can only commence once a valid notice invoking arbitration has been sent by the applicant to the other party and there has been a failure or refusal on the part of that other party in complying with the requirements. Insofar as the first issue is concerned, we are of the opinion that the observation made by us in Arif Azimji do not require clarification and should be construed as explained therein. On the second issue, it was observed by us in para 16 of Arif Azim case that referral court, while exercising their powers under section 11 of the 1996 Act, are under a duty to prima facie examine and reject non-arbitrable or dead claims so as to protect the other party from being drawn into a time-consuming and costly arbitration process. Our findings of both the aforesaid issues have been summarized in para 92 of the decision. Thus, we can skip this, my lord. Then the Honorable Court refers to Vidya Durolia, my lord. And then it also refers to interplay, my lord. Para 135. Para 136, I'll read, my lord. Thus, we clarify that while determining the issue of limitation in exercise of power under 11(6) of the Act, the referral court should limit its inquiry to examining whether section 11 application has been filed within the period of limitation of 3 years or not. The date of commencement of limitation period for this purpose will have to be construed as per the decision in Arif Azim. I can skip that, my lord. So this is the conclusion of judgment, my lord. Flag C, my lord. This is again 7 November 25 and Justice Chandrachud, Justice Pardiwala and Manoj Mishra. Para 34.
Para 34.
34.
Yes.
A 3-judge bench of this court in Vidya Durolia, Durga Trading, while dealing with the scope of power of the referral court under section 8 to 11, respectively endorsed the prima facie test and opined that courts at the referral stage can interfere only in rare cases where it is manifest that the claims are ex facie, time barred and dead, or there is no subsisting disputes. Such a restricted and limited review was considered necessary to check and protect parties from being forced to arbitrate when the matter is demonstrably non-arbitrable and to cut off the dead wood. Then, my lord, I'll just take your lordship to para 41. This is a reference to interplay, my lord. However, subsequently, very pertinent observations were made by a 7-judge bench of this court in interplay also. So, it may not be relevant, my lord. Para 42.
Yes.
In light of the aforesaid observation, the ratio of Arif Azim was considered by this very bench of SBI General Company in Chris Spinning, the previous judgment, my lord.
Which paragraph reading?
42.
Okay. Yes.
In light of the aforesaid observation, the ratio of Arif Azim was reconsidered by this very bench in SBI General Insurance versus Chris Spinning. The position of law was clarified as thus. I've already read, my lord, in the previous judgment.
Yes.
Para 132, 135, all these, my lord. Now, I'll refer to para 43 and 47, my lord.
Yes.
Therefore, while determining the issue of limitation in the exercise of power under section 11(6) of the 96 Act, the referral court must only conduct a limited inquiry for the purpose of examining whether the section 11(6) application has been filed within the limitation period of 3 years or not. At this stage, it would not be proper for the referral court to indulge in an intricate evidentiary inquiry into the question of whether the claims raised by the petitioner are time barred. Para 47, my lord, reiterates the same proposition, my lord. And para 51, my lord.
Yes.
It is now well settled law that at the stage of section 11 application, the referral court need only to examine whether the arbitration agreement exists, nothing more, nothing less. This approach holds the intention of the parties at the time of entering into the agreement to refer all disputes arising between themselves to arbitration. However, some parties might take undue advantage of such a limited scope of judicial interference of the referral court. Hence, and force other parties to the agreement into participating in a time-consuming and costly arbitration process. This is especially possible. So these are observation, my lord. So, my lord, the sum and substance of my submission, my lord, and supported by 3 decisions, that if the claim is time barred or not, my lord, that is for the arbitrator to decide. But from the date of invoking arbitration.
But regarding 11.6 invocation is different, and the claim the time bar are 2 different aspects.
Here is a case, my lord, on both counts they are time barred, but I am not pressing the first limitation, my lord, I am pressing the second limitation, my lord.
Yes.
That's the submission, my lord.
Let's. Only issue here is, your lordships have seen that my lords have used, they have used 2 expressions. They use the expression, my lords, whether it's a dead claim.
Whether it is a
dead claim.
Yes.
In starting from RF Azim, my lords, your lordships have seen RF Azim, then crisping.
The matter is called out.
In the court.
Mr. Paul can reply, my lord. I have so come to tomorrow.
Yes.
Limited
it's lunchtime also.
Or we can have it tomorrow, my lords. I can respond to your lordship. Limited issue is, my lords, that whether your lordships, if it is a dead claim, your lordships will not entertain it under section 11. Otherwise,
what's been raised by this Arif Azim company, the only consideration now is whether, now as per everything is peculiar to the facts of each case. Now your case we're looking at, if that is your stated position, that in 19 November 2020 is the time you had raised, your first.
We had written mailers to them saying that this is the disputed amount which you do not pay, so we would want to invoke arbitration. That's the expression used over there. That, my lords, for the purposes of, because now the issue that comes in, my lords, and what I want to have to indicate to your lordships is, my lords, there is this issue of satisfaction. Now the satisfaction,
whether that will go, that is the only thing, whether it's called go to satisfaction.
No, my lords,
we're not going to go, see Mr. Paul, we're not going to go to examining whether the debt claim or whether...
No, my lords, I am saying that when it is before your lordships saying that, my lords, there has been a development or a satisfaction of a part of the claim on a certain date, my lords, that would ensure that the date of limitation continues. 137, my lords, I'll have to satisfy your lordships on that.
Satisfy that. Yeah.
Lordships.
Those 2 also we have another benches.
Because the other difficulty is, my lords, your lordships have seen Arif Azim, crisping, all these judgments, my lords, are by smaller benches. In view of what has been laid down in interplay, my lords.
Interpretation.
My lords, they have never interpreted interplay. That's what I'll again take your lordships, because Arif Azim, my lords, says,
to interplay
my lords, reference to a judgment.
Or whether they've carved out, an exception. I don't know. But I've not seen.
My lords, your lordships are correct. Reference to a judgment is a different thing. Yes. Carving out an exception, my lords, is a different thing.
Distinguishing rather.
Because interplay has not dealt with the limitation at all, my lord.
No,
I'll take your lordships to the specific paragraphs. That only issue is, my lords, they say in interplay is whether under section 11 your lordships are to examine that or not. They said you can't raise it under section 16.
According to our understanding, that once application is made, up to arbitrator decide.
Lordship.
That's the general, like why it is a headache. The only thing is that you come before the court because there's some, there's agreement about, no one, one is like, he's not
if I can use this expression, my lords,
if
I seek your lordship's indulgence to use this expression, section 11, my lords, is more of procedural law than of substantive law. Your lordships are only, my lords, appointing somebody who's going to decide this issue.
But interesting point has been raised.
Since he's raised it, my lords, I'll respond to it. Tomorrow, my lords.
This matter for hearing tomorrow. Yes. Yes, submissions ready? Not for arguments any further.
No arguments. My lordship.
Please, Your Lordship.
Your file is submissions.
I'm
Why?
seeking time, Your Lordship.
You're convening a bench specially just to receive some submissions. This is very. How much cost you'll pay? You've given yours?
Yes, my lordship. And soft copy also, my lordship.
Yes, you kindly give the soft copy also. Seems copy. Where's Mr. Deb?
He has some personal difficulties, Your Lordship.
He's not in court today.
He's in court.
Then call him. He must be here. We're the only court sitting now, I think. Is he in court right now?
No, Your Lordship.
Where is he gone?
Only after court 4 today, and he left. He has some personal difficulties, Your Lordship. Let this matter come after 1 week, Your Lordship.
Tomorrow?
It will be okay, Your Lordship. He'll be here personally.
Oh, we can't keep this matter pending just for film submission. Yes, how last week also? You have considered into one document.
Yes, one document.
Yes. What about state?
We are yet to file money.
Yes.
AG is supposed to pay money, but I'm sorry, money.
Can you within 1 week you please file it? Yes. MS Anamari on behalf of the petitioner and MS Arkoni on behalf of the state respondents. Pray for allowed further. We'll give you 2 weeks time to file arguments. Stop. And they will not pass it. Next date, if you don't file it, then you will pay a cost.
Yes, sir.
Connected matter is this together also.